Madam, display.
Court officer, court officer. Proceedings ಕಾಣಿಸ್ತಿಲ್ಲ ನೋಡಿ. ವಿಡಿಯೋ ಆಫ್ ಆಗಿದೆ.
Court is not audible.
This list is matter on 16th.
16th date.
Lord, this matter where your lordship said refer the parties to demands. Lord, no evaluation is being undertaken by demands due to
Why?
shortage of staff. They say there is a Lord, the doctors who are conducting the evaluation, they're all transferred, and they were mostly students. Lord, now they are not there. We'll have to wait for another 3 months, is what is indicated. Lord, may I request for the matter to be taken up, Lord, for some arrangement of visitation. There are ensuing vacations for the child also.
This is matter on 17th. 17th. Yes.
Adjournment. Adjournment. Serial number 54 in the first list, my lord. Today there is a personal inconvenience for me. Please kindly have it next week on 17th and in.
50.
54 Mustaq Ahmad.
Yes, my lord.
A. N. Krishna Swami.
Next week, 17th.
This is on 24th of April. At the request of non-counsel for the appellant. So the copy on him.
Yes.
My lord, serial number 65, my lord.
17, my lord. Serial number 17. First list.
Just call the adjournments.
Page-wise adjournments.
Yes, Mr. Mahesh.
Yes, madam. Serial number 17, I am for appellant. Mr. Shansraj is for respondent 1 and 2. Yesterday night he called me and said that he is not well. May request for to be posted after the vacation, my lord.
Yes.
please.
Page wise adjournments. Page number 11, serial number 35, 36.
Page number 2, my lord, please.
Parted matter.
Serial number 7, my lord. Kindly it may be adjourned to next week, my lord.
Why?
Senior is not feeling well, my lord.
It's a
very serious, my
2013
lord.
matter. We will see when the matter reaches. If it requires your senior's presence, then we will adjourn. Yes.
Page number 12, serial number 37 to 39. Page number 13, 40 to 50.
Serial number 42.
14,
Serial number 42, appearing for the respondent in this case.
14 or 40?
42.
42.
Petitioner, I have objection for this because last two occasions they did the same thing. It
Please
is a-
wait, please
Yes,
wait. Yes.
Yes, please.
Page number
Number 47. Serial number 47. I have to produce one that complaint copy, man. I'm not available to because it is already filed before the family court. 1 week time may be granted.
You appear for whom?
Respondent, my lord.
Have you
Yeah.
informed the petitioner?
Pardon?
Have you informed the
No,
petitioner?
no, my lord.
Then, wait, yes.
page number 14, serial number 51 to 57. Page number 15, serial number 58 to 63.
No, this final hearing matters from from 64 to 70.
Yes,
Give the dates
yes.
in the month of June. One case, 1 day.
Oh,
Yes. Please call the list.
Parted matter, list 1, serial number 1. Shintan Chinnappa, petitioner, appellant,
Serial
applicant.
list number 3, my lord. Serial number 20, I will take substitute service.
We'll see that. Yes. Yes. I think I should better release it from parted. Again, all of you have to start. I have to hear everything.
I will have to restart.
Let it go to the court which is having the roster. Release from parted. Yes.
Serial number 2, it is Sidramaya, for petitioner. Mrs. Prakash.
Yes.
My lord, the first petition is filed by CP 353 of 2024 to transfer the original suit from Shumaga to Haryana. The another case is filed by the respondent seeking transfer.
Let me understand
Yes,
the case.
Yes,
It's a
please.
wife's petition.
No, it's not wife, my lord. In CP number 353 of 2024, filed by PS Praveen Kumar. First case 353 of 24,
CP 353 is filed by whom?
filed by
You.
PS Praveen Kumar, my client,
Uh,
for the death benefit of wife of the petitioner.
uh,
Disha has died while she was in service in Bescom, Honnali.
mm,
Honnali comes within the jurisdiction of Davangere district.
mm.
Haryana Senior Civil Court is having the jurisdiction over Honnali. Hence, the petitioner has filed a suit for death benefit of Disha, wife of the petitioner, before the senior civil judge at Haryana. Mother-in-law of the petitioner has filed one more suit at Shumaga. So my submission, my lord, is the marriage between the petitioner and the deceased was performed at Davangere. It was a registered marriage. First submission. Secondly, she was working at Honnali and residing at Honnali within the jurisdiction of Haryana Senior Civil Judge. The cause of action arises from Haryana Senior Civil Judge. So we have filed
Determines that the deceased mother.
a deceased mother.
Mm.
So, my lord, either of the case, a matter has to be transferred. Whether my case has to be transferred to Shumaga or that case has to be transferred to Haryana.
So we'll transfer your case to that place.
Anything, my lord, my submission is like this.
No,
So,
I'm saying anyhow, because
yes.
mother-in-law, old lady,
60 years.
let it be transferred to that place, both the
Anything.
cases.
So, these are all my submissions, my lord.
Yes.
So,
The CP 353 of 2024 is filed seeking to transfer OS number 9 of 2024 from the code of the second additional district and session judge Shimoga and transfer the same to the senior civil judge and JMFC, Harihara. And
367 of 2024.
CP 367 of 2024 is filed seeking transfer of
P&SC 1 of 2024.
P&SC has been converted as original suit now.
that's converted as OS number 100.
100 of 24.
OS number, your case is OS number?
My lord,
To transfer the pending OS number 100 of 2024 from the senior civil judge and JMFC Harihara to the second additional district and session judge Shimoga to be tried along with OS number 9 of 2024. As both the matters are connected, the same are disposed of by common order. The facts of the case are the petitioner married the respondent's daughter on 7/5/2009.
1/7/2019. In my petition 353 up to.
Even the dates also will change in the petition about the marriage.
My lord, I am stating about the registration of the marriage. It was registered on 1/7/2019.
You say 7/5/2019 in your case.
Pardon, ma'am?
The marriage between the respondent and the daughter of the petitioner solemnized on 7/5/2019.
Yes, ma'am.
The marriage was solemnized on 7/5/2019. According, it is a case of the, now the petitioner, she died on which date?
She died on, my lord, 29/8/2021. Yes.
She died on 29/8/2011.
21.
2021.
Yes.
It is a case of the voice number
100.
Voice number 100 of 2024 is filed by the mother of
Husband.
Husband, Praveen Kumar.
Mother, my lord, P&SC before,
that's what
OS number 9.
that's
is
what
my
he's saying
petition.
100 that's what I'm looking at it. The mother has filed P&SC number 1 of 2024 on the file of the
Shimoga.
on the file of the second additional district and session judge Shimoga. Whereas the husband had filed OS number 100 of 2024
Haryana.
on the file of the
Senior civil judge at Harihara.
on senior civil judge and JMFC Harihara, seeking a declaration that is entitled for the benefits, pensionary benefits of the deceased. Now, both the son-in-law and the
And one
mother-in-law,
more submission, my lord. P&SC filed by mother-in-law has been converted as OS 9 of 2024 after filing objection.
P&SC is converted as OS number 9 of 2024.
Yes, please.
Now, both the son-in-law and the mother-in-law are before this court. They want the respective cases to be transferred and tried along with the case which is filed by them pending at Harihara and Shimoga. Land counsel appearing for the son-in-law submits that all the wife, the marriage had taken place at Harihara. They have stayed together at
Davangere. Marriage was registered at Davangere.
Davangere and they've last resided in Harihara.
In Honnali, within the jurisdiction of Harihara.
They were residing within the jurisdiction of the courts at Harihara. As such, the suit, which is the P&SC, which is converted as OS number 9 of 2024, has to be transferred to Harihara, and the courts at Harihara are having jurisdiction to try the same. Land counsel appearing for the mother-in-law submits that the late daughter, deceased daughter, has executed a will in her favor.
Yes.
And as she is residing
In
in
the year
Shimoga,
2020, my lord.
as she is residing in Shimoga, and also what is her age?
60 years, my lord. 61
Hey,
years now.
hey,
Now
age,
60.
age of the,
I state in para.
And she's 61 years old. She is a senior citizen. And as both the cases have to be tried together, considering her age, the suit that is filed with the son-in-law needs to be transferred to Shimoga. This one, having heard the counsels on either side, produce the material on record. Both suits filed by both son-in-law and mother-in-law are pertaining to the benefits and the will that is executed by the deceased wife or daughter. Admittedly, the mother-in-law is residing in Shimoga and she's aged 61 years. Either the cases have to be transferred to Harihara or have to be transferred to Shimoga, as both have to be tried together. Considering the fact that the mother-in-law is aged 61 years and a senior citizen, this court deems it appropriate to withdraw OS number 100 of 2024 pending on the file of the so-and-so and transfer the same to so-and-so. Accordingly, CP 353 of 2024 is dismissed and CP 367 of 2024 is allowed.
My lords, one
date may
indulgence, my
kindly
lords.
be fixed for appearance of the parties.
Without further notice, the parties shall appear before the court after vacation
Any date may.
on 10th of June.
My lords,
Tenth of
one indulgence I'll seek, my lords, in so far as CP 367 of 2024, my lords. I may be just permitted to file my Wakalat Nama in the registry, my lords, since the matter is disposed for respondent number 2, 3 and 4, my lords.
In CP number
367 of 2024.
367 of 2024, learned counsel appearing for respondent number
2, 3 and 4, my lords.
2, 3 and 4 is permitted to file wakalat within 1 week.
Grateful.
Direction for early disposal.
No,
may
no.
continue.
Serial number 3,
Date has put.
Mahesh M for petitioner. Harish Kumar.
This is a vice petitioner, my lords,
Hmm.
seeking for transfer of the divorce petition which is filed by her husband in MC number 39/2024, filed at Honorable Court, Nelmangala, Senior Division, my lords.
Nilmangala to
Nelmangala to Bangalore Family Court, my lords.
distance.
Around 40 to 50 kilometers, my lords. The wife is residing in Kormangala and she is having a 5-year-old boy.
Yes, what do you say?
From Bangalore to Nirmangala, 20 to 25 kilometers distance is there. It is outskirts of Bangalore city. Nirmangala is situated outskirts of Bangalore city. And my lord, she has filed a partition suit in the year 2022 before the Nirmangala court, same court where I filed divorce petition. That petition, in that suit, she has been contesting. Every date of hearing, she is appearing before the court at Nirmangala, where I have filed this divorce petition. This fact is not forthcoming in the petition.
My lords,
It is,
my lordship
suppression
may
of facts.
kindly peruse the,
As on that day also you were staying in Bangalore.
my lords, I am staying
Properties are
in
situated-
Bangalore, my lords. And even in the,
Have you sought for transfer of that suit?
my lords,
Any of that cannot be done.
my lords, OS cases, it will run by an advocate, but it will
Because
not be
it is pending,
much
It
difficult.
is pending and you have to go to the court. Why should we transfer?
My lords,
You are able to
even
go
the
there.
summons in MC number 39, though it has been shown as Nelmangala as an address, but the actual service, it has been done to the Kormangala only.
No,
Actual
we accept
residence is,
that you are not
actual
there in-
residence is in
You are
Kormangala.
not there. You are in Bangalore. Let us say
Please,
that you are in
please.
Bangalore.
They
But
will not
already-
dispute that.
Already a suit is pending. You are attending that court. So in the same court he has instituted this. You attend that also.
My lords, the differences in the civil courts as well as in family cases, my lords, it will much difference.
In that court, you will get there will be a speedy disposal. Bangalore court more pendency.
My lords, in the family court, it will be not only for the convenient of my lords, even the 5 years kid is there. So I have to look after that. This is a matter, vindictive petition has been filed by the husband. It is purely a vindictive petition, my lords. In 2022, divorce DV case has been pending before the Honorable 4th MMTC, my lords, in Bangalore.
That is posted
My lords,
for judgment.
it is almost at the verge of what?
That petition, domestic violence act petition, is posted for judgment. It is now, my lord, court has to pronounce the judgment. There is no role of the parties in the that said proceedings.
For all the
Now only pending is before the Nelmangla court, two proceedings are pending. One is the partition suit, another is a divorce petition. Two petitions, two proceedings are pending before the Nelmangla court. Another fact is mother of the husband is bedridden. She is not able to move anywhere in the I have produced the medical records also. Annex R3. I have produced the medical records of the mother. Mother and son is residing in the house. Son has to take care of the mother. This is the difficulty of the husband.
My lords, this is purely a vindictive petitions cannot be appreciated like this, my lords. 2022, at that DV case, it is for the entire case proceedings, my lords, he has appeared. It is at the verge of finality.
Yes.
My lord, this is after that, my lords, it is after 2 years. It is 2024, he files this divorce petitions, my lords, in the Nelmangla, showing the address that is a Nelmangla, but actual service is done to the address in the Kormangala, my lords. The difficulties is this, my lords, and the petition, the respondent husband, is a businessman carrying with the two goods carrier, which is doing the business of that business. So it's not difficult for him to make a leave or something and to come to the Bangalore. It is not much difficult for him also.
How are you attending the suit? That you please
My
tell
lords,
the court.
in a suit, my lords, it's not that it only with the evidence stage or some
Even
stages
in
it
these
will
proceedings
come.
also, even in these proceedings also, when your presence is required, then only you will go.
My lord,
And
this
the
is,
suit will take years together.
my lord, this
The
is a,
family proceedings will conclude earlier.
this is a
earliest.
vindictive petitions, my lord, which he has filed.
Not
Vindictive
considered at
petitions
this
cannot be
stage.
appreciated like this, my lord.
Please come.
And it is a family divorce petition which he has filed on the false allegations against the wife of cruelty and something else.
Present petition is filed seeking
Please.
transfer of MC number 39 of 2024 pending before the second edition senior civil judge and JMFC Nelmangala, Bangalore to the family court at Bangalore. The facts are the marriage taken place on 5/6/2009 at Dodbalapura, and in the wedlock they're blessed with a boy on 3/3/2020. In the light of the differences between the parties on 3/1/2022, wife had filed criminal miscellaneous number 20 of 2022 before the Metropolitan Magistrate Traffic Court, 4th Bangalore, under Section 12 of the Domestic Violence Act. The husband had filed the MC number 039 of 2024 seeking dissolution of marriage before the second edition senior civil judge and JMFC Nelmangala. Now the present petition is filed seeking transfer. It is submitted that the wife has to take care of the son, and also the distance is about 40 kilometers. It's difficult for the wife to travel. Next para. Learned counsel appearing for the respondent husband submits that in fact the wife had instituted OS number
322 of 2022 before senior civil judge JMFC Nelmangla.
322 of
2022.
2022 before the courts at Nelmangala seeking partition. It is submitted that the said fact was not stated before this court, and with suppressing the said fact, the present petition is filed. It is submitted that when the wife is attending the courts in the partition suit, there is no difficulty for her to attend the court at Nelmangala. Next para, the counsels on the side there is the material on record. Considering the fact that already the OS number so and so, which is filed for partition, is pending on the file of the so and so court, and as a wife is pursuing the same, and this court finds no reason to transfer this case to the courts at Bangalore. Further, even the pendency at Nelmangala is less compared to Bangalore, and there would be a speedy disposal. In that view of the matter, this court finds no reasons to
If
transfer.
the speedy direction may kindly be given for expeditious disposal of the petition.
The husband shall cooperate for the speedy disposal. MC of which year?
2024.
It's a vindictive petition. After 2 years, he filed this case.
Yes, next.
Please.
Number 4, Chetan B for petitioner. N. Suresha.
Yes.
It is a wife petition, my lordship.
Hmm.
From transfer family court of Mysore to principal family court of Hassan, my lordship.
Where is the book? Okay, you know the book. Hmm.
Mysore to Hassan, my lordship.
Distance?
Distance is 111 kilometers, my lordship.
111? What do you say?
In this case, synopsis, they have not given the clear copy. Synopsis page number 1 ನಲ್ಲಿ criminal miss 975 of 24 ಅಂತ annexer B ಅಂತಾರೆ. ಈಗ ಇದರಲ್ಲಿ MC 7 of 25 ಯಾವ ಇದು ಟ್ಯಾಲಿ ಆಗ್ತಾ ಇಲ್ಲ. ಆಮೇಲೆ ನಮ್ದು our petition is the earlier petition. MC 975 of 24 is the earlier petition. We filed the petition before the family court Mysore. Earlier petition was last decided there. Jurisdiction there it comes. I will file the I will file the objection, but the documents they have not. They have
No, now I understood the fact that according to you, the MC that's filed by you is the first.
Yes.
Prior to his petition.
Yes. And last
Then,
decided there.
Huh?
Last decided
Yes.
there.
No, even considering the both, why the petition cannot be transferred? There should be a reason for that. There are children out of the wedlock?
No.
Yes. The distance is 100 and so kilometers. We'll consider the wife's inconvenience and will transfer it. What are the reasons for not transferring it?
Because the last decided in my.
That is as per when you have to file the petition, that is what it is. The act itself says that where the wife is residing, it can be at present. Yes, please. The present petition is filed seeking transfer of MC number 975/2024 pending on the file of the third additional principal judge family court at Mysore to the principal family court at Hassan. Land counsel for the petitioner submits that the marriage had taken place on 7/9/2018 and in view of the differences between the parties, the wife started residing at Mysore and she has filed criminal miscellaneous number 97 of 2024 seeking maintenance. On 8/1/2025, the husband had filed MC number 7 of 2025 at Hassan seeking divorce or restitution?
Divorce.
Seeking divorce. It is submitted that the wife is staying at Mysore and the distance between both the places is about 111 kilometers and it is difficult for the wife to travel. Land counsel appearing with the respondent submits that the last marriage had taken place at Hassan.
Please.
And they last resided together at Hassan and they have rightly filed the petition and there are no reasons to transfer. Next para. Having heard so and so, having heard the land counsel of the petitioner, counsel for the petition, the respondent, peruse the material on record. There is no dispute about the fact that the marriage had taken place at Hassan. And in view of the differences between the parties, the wife is staying at Mysore. And also the distance between both the places is about 111 kilometers. In that view of the matter, considering the inconvenience being caused to the wife, this court is the CP is allowed and so is withdrawn and transferred to so and so. There will be usual that you take. Yes. Yes, next.
Serial number 5. Harish Bandari T for petitioner.
For the respondent.
Petition.
What are these two petitions?
Lord, there are. Lord, both by the tenant.
Both by the tenants.
Order of the eviction. My lord.
Order of eviction is passed.
Yes.
If I remember on the last occasion, you were saying something that there was an undertaking that you are ready to vacate the premises. This is not the case?
This is not the case. My lord,
Original that the eviction petition is filed in which year?
Original, it is filed in the year 2013.
Okay, now the one is HRC 3 of 2013.
Yes.
And HRRP 5.
My lord, the eviction petition that is brought against the tenant seeking for eviction under the provisions of Karnataka Rent Act. Two grounds are sought for.
Yes.
For eviction of the tenant. One is self-occupation. Second is a special ground for eviction provided for a widow for a self-occupation. Only ground that is pleaded is self-occupation. This may kindly be borne in mind. The tenant was occupying these premises, which is a residential premises, by virtue of a Mulageni deed, which was entered into between the landlord and the tenant in the year 1961. Mulageni tenancy means it is a permanent lease. The permanent lease deed provided for a forfeiture clause that if the tenant commits default in the matter of payment of rent for a consecutive period of 5 years, he will incur forfeiture.
Why on the last occasion this was adjourned? I think I heard
it was heard. And a question will take some time, your lordship, agenda matter.
Today also it will
take some time.
Is this matter? After vacation, we'll list it. Delete from part.
My lord, could it?
Huh?
My lordship may not release, my lord, it could be.
Then list it, this is matter as part heard.
Yes.
On
after vacation.
My lord, before vacation a date could be given, my lord, some other.
Because of this Lok Adalat, there are several matters. Court may not able to give time. 10th of June.
Could it be on little early, my lord? 6th or 7th?
9th.
Yes.
Yes, next.
My lord, 9th and 10th, my lord, I will not be. Or my lord, after 12th, your lordship have.
16th.
6th. Your lordship may not release, my lord.
Part heard only it's there.
Grateful.
Yes.
Then number 7.
Yes.
Pradeep B for appellant.
Yes, Pradeep.
Appear to the respondent, my lord. My lord, kindly pray week's time, my lord.
We'll see. That's what I'm saying. If required, your senior's presence is required, we'll then adjourn. On what ground you are before the.
Involvement of the vehicle is questioned. My lordship has heard some time on that. He's requesting his senior is not keeping well. Any date, my lord, 15th or 16th.
What is the likelihood of your success in
The
this?
2 FIR has been lodged.
No. I'm asking what is the likelihood of success in this appeal?
If they
of
come also,
insurance
they won't
company.
succeed, I think, my lord.
Insurance company will succeed.
Succeed, definitely.
This is March after vacation. It's the same caption. Yes, next.
Cell number 8.
Yes.
Cell number 8. Srinivas K.
Yes.
The last occasion I made a submission and I produced the copy of the order passed in another MFA, which is arising out of the same accident in MEC to 73/14, wherein this court has held the vehicle involved is Tata Claris, not Padmini, car Padmini. So on that basis, this appeal has to be allowed.
It's only MBC number 74 of 2006.
No, both are before the same MACT. Both the time petitions are old against the other one. It was challenged before this on court.
And this is not a common order.
No, common.
Huh?
Not common order.
Let's see the facts of the case.
In both the cases, MACT was held that Padmini car was involved, against which two appeals were, that appeal filed by one, they have filed appeal before this on court, and this on finding is not, it is Qualis, Tata Qualis is involved, not Padmini. So on the same line, para 2 of the judgment in MFA 5113/2009. Para 3 may be kindly, may read the para.
1 minute. That Tata Qualis, the owner and the insurer are not made parties.
No.
You are the insurer of Padmini.
Yes, yes, I am the insurer of Padmini.
For respondent.
Initially, the claim petition was dismissed, against which appeals were filed before this on court. This on court in MFA 5, and nobody has led the evidence, additional evidence. Ultimately, it was all right.
Yes.
I am for the respondent, Your Worship.
Respondent?
Respondent, all the respondents, sir.
You appear for the claimants.
Claimants.
Yes.
Have you seen this?
I'm not
Order
I'm not-
pertaining to the very same accident, when the trial, in that case, the MVC was dismissed, holding that Tata Padmini is not the car which is involved, but it is Qualis. Against that, they filed a MFA. MFA is also dismissed, confirming the order of the.
No, no, MFA is not dismissed, means for fresh dispo,
That
for
is,
fresh
after
adjudication.
that, read it, look at it, we'll pass orders. Let him look at it after next case, call that.
The only contention of the petition.
Please look at that order you have got now. You didn't have the benefit of looking at it. Yes, next.
Serial number 9.
Yes.
For dismissal, serial number 9. Shankar Narayan Bhatt, petitioner.
Sorry, one last occasion. It was listed for awaiting service to the respondent.
It's a CP of 2023.
Yes, ma'am. That
No representation.
husband has been avoiding the service of notice. We have taken
So
three.
what, there is a stay in this,
Yes, yes.
and the stay is continuing from 2023.
True, Vila. The husband who has filed the petition, a suit against the wife, He's avoiding the service of notice in spite of.
Now, somebody must be representing the suit.
Yes, that's why last occasion, not before your last year, I requested to take up notice to the council.
Yes, land counsel for the delete from the caption dismissal. Land counsel, the petition is permitted to take out hand summons on the counsel appearing for the respondent before the trial court.
And also through.
And shall file a memo to that effect by second of June. This,
Serial number
there
10.
is no extension of say.
No, it is not condition order, it was granted.
It's an absolute stay.
Yes, madam.
Yes.
Serial number 10. Spurti Hegdayani for petitioners.
My lords, suppose this month's last date of occasion, I was held up in other matter, my lords. I couldn't appear on last date of hearing, my lords. My lords, the trial court advocate has been served with a copy, my lords. I also filed an acknowledgement to this effect.
There is a memo.
Memo, my lords, 22/4/2024 itself I have filed, my lords.
To whom you have served?
My lords, on the counsel who appear on behalf of the
Submitted
respondent, my
that
lords.
as per the orders passed by this court. They serve the notice on the counsel appearing before the trial court. The advocate's name is Chandrasekhara.
Please, my lords.
On 4/4/2024. The memo is taken on record. Print the name of the advocate and the notice to so and so is sufficient. Yes, list this matter on 16th.
Grateful, my lords.
Yes, next. Delete from the caption for dismissal.
Serial number 11. Satish T for appellant. Here is Sanmati.
What is this about?
My lords, I'm appearing on behalf of the owner of the vehicle, my lords. It's my former representation, my lords, and they have taken a time to file in translated versions, my lords. For that reason,
What translated versions?
of the documents which are relying, my lords.
Judgment is in order is in Kannada in English.
No, my lords, the documents which they are relying, my lords.
Not document, not required. Anyhow, they are not there. We'll hear it. Let's see. What is the order?
My lords, my apologies, my lords. I have.
There is no need to discuss. Oh, it is dismissed.
Please, my lords.
Please come. The present petition is appeal is filed. Agreed with the dismissal of MVC number 55/2020, dated 31st December 2013 by so and so. The claimant is before this court. The claim petition is filed under section 166 of the Motor Vehicles Act, seeking compensation of an amount of rupees 5 lakh for the injuries sustained by the claimant in the road accident that took place on 17/3/2010. It is stated that on 17/3/2010 at about 5 p.m., claimant was on the Madhugiri Pavagada road by bicycle on the left side of the road. At that time, a motorcycle bearing registration number KA09EA 6060 came driven by its driver in a rash and negligent manner from and dashed against the petitioner's cycle and caused accident. He sustained injuries and he was shifted to the hospital, several hospitals, and he took treatment and spent a huge amount. It is stated that it is stated that the name of the driver of the motor vehicle is Ramesh, and there is and also about the registration number of the vehicle. The rider of the vehicle assured him that he would bear the hospital expenses and requested not to file case against him. It is stated that before the court, the son of the claimant was examined as PW2. In his chief affidavit, it is stated that accident caused by Ramesh, but the witness in the cross-examination given evidence that the vehicle belongs to Lokesh and he has caused accident to his father and deposed that the said vehicle was driven by Lokesh. He has given clear evidence that he has seen the accident. The court had dismissed the claim petition, observing that the nature of the evidence given by PW 1 and 2 go to show that there is no consistency regarding who is the owner of the offending vehicle as well as who was driving the same at the time of accident. The court also has considered the fact that the accident had taken place on 17/3/2010 and the complaint is filed on 27/3/2010. Further, in the criminal case, the accused Ramesh has pleaded guilty. The court has observed that mere pleading guilty by the driver of the offending vehicle cannot be a ground for the court to come to the conclusion that the accident has happened. The said vehicle is involved in the accident, and because of his negligence, the accident had taken place. Considering the inconsistency between the evidence of PW1 and PW2, the court had dismissed the claim petition. This court had perused the order sheet. This is an appeal of 2014. On several occasions, either the appellant is not present or he sought for time. On 7/1/2025, a coordinate bench of this court has recorded that no representation on either side on call, and also that there was no representation on 23/11/2024. And on 2/12/2024, sought time and accordingly time was granted. And the court observes that even today, even on 7/1/2025, there is no representation and hence directed the matter to be listed for dismissal on 13/2/2025. And again, when the matter came up on 13/2/2025, Land Counsel for the appellant sought time to file translated copies. And again, 2 weeks' time is granted. Then the matter came up on 27/3/2025. On that day also, there was no representation. Hence, the matter is directed to be listed today under the caption dismissal. Today also, there is no representation. This is an appeal of 2014, and as such, this court is inclined to consider the appeal on the merits of the matter instead of dismissing the same for non-prosecution. The Land Counsel appearing for the owner of the vehicle submits that the court had rightly held that you are the owner of the vehicle, that rightly held that had rightly dismissed the petition and there are no grounds. You appear for the insurance company. In this case, then rightly held that and rightly dismissed the petition, and there are no grounds to interfere with the well-considered order passed by the court. Next, we are having got the Land Counsel for the Land Counsel appearing with the owner of the vehicle, there is entire material on record. It is a case of the claimant that the vehicle involved in the accident is driven by one Ramesh, and yet they have given the number of the vehicle. With a delay, the complaint is given to the police. The complaint is given by the son of the claimant, and in the chief examination, in the chief affidavit that is filed, he submits that Ramesh is the owner and the driver of the offending vehicle. In the cross-examination, it is stated that the vehicle belongs to one Lokesh, and the Lokesh is driving the vehicle. The court, the tribunal has rightly held that the mere pleading of guilt by one Ramesh, who is alleged to be the driver, cannot be the ground for the court to come to such a conclusion as put forth by the claimants. And the court had right, considering these inconsistencies, court had rightly dismissed the claim petition, and this court finds no reasons to interfere. Accordingly, dismissed.
Cell number 12. Gunashekar R for appellant, Girish B. Baldare.
Appellant's counsel, my lord.
For respondent number 2. And for respondent number 1, my lords, I'm the claimant before the trial court, my lords. The question is, my lords, now they are challenging the involvement of vehicle, my lords. And in my lords, if complaint, my lords, which is given by the owner of the vehicle, who is the complainant, my lords, in which he states that while he was going in the car along with his driver, who is his uncle, maternal uncle, he was going, and that time he was riding the car in rash and negligent manner, and accident was caused. And he also states that they were on presumption that the claimant would file the complaint. Because of that, they lost the complaint later on, my lords. And in the exhibits, my lords,
as per your own petition and your own averments, immediately after the accident, you've been taken to a particular hospital.
Please, my lords.
You don't produce the MLC pertaining to that hospital. Thereafter, you will be taken to the very same hospital,
please, my lords,
for which belongs to the offending vehicle, owner of the offending vehicle.
My lords, the owner, my lords, who is Dr. Srinivas, he only referred the claimant for CT scan, my lords. The other documents in signatures of documents.
Is it the case that you know Srinivas much from?
No, my lords. No, my lords.
So how did you go to him?
In complaint, they state that, my lords, driver and the owner of the vehicle, which is Dr. Srinivas, taken the claimant to the hospital, my lords. That's how they have taken him.
Is it the complaint also?
It is in complaint.
Who has admitted you in the hospital?
It is in complaint. They state, my lords, the Srinivas, Dr. Srinivas, along with Ramesh, who is the driver, had taken the injured to the hospital.
Correct. My lord, the fact is they went to a different hospital.
Which is, my lords, R3, my lords.
They say that they took him to Mangala Hospital, but I have
Srinivas is examined.
No, my lords.
no, but I have produced the MLC which shows that he didn't go to Mangala Hospital. He went to a different hospital,
My lords.
Sri
If-
Chamarajendra Hospital.
It is not their
After
case that they never went to Chamraja Hospital.
No, we don't say they didn't.
Not
do.
you.
They have not examined.
They have not mentioned that at all. They have not mentioned that hospital at all.
Even
They are
cross examination
inconsistent.
also, they have not asked any question with regarding that, my lords. If my lords see exhibit R3, my lords, which is in written, my lords, there is no specific mention about.
This is matter after vacation. Give a date. Yes, next. Delete from the caption for dismissal. Yes, next.
Cell number 13.
Yes.
RB Sadashiv for appellant.
What is this? Seeking enhancement.
Enhancement.
Huh?
Enhancement.
You have a copy?
I'm not, not being, but anyway, can I take the assistance of the lower court records?
Yes. Take that, give him.
Lord, this is a case of enhancement. Can I proceed, Your Lordship, to have the,
Let's go to that.
yes, issue number 2, my lord, straight to
No, let's straight away go to the table at page number 20.
page number 20.
Table. So first tell the court what are the injuries.
I'll just go through it.
Hmm.
Can I proceed, Your Lordship, to have a look at para 2, my lord, I'm sorry, issue number 2, my lord, can I just quickly read it along with you?
No, we can straight away come to pain and suffering.
No, I'd like to see what are the injuries that he had suffered.
There it is mentioned. The petitioner had suffered with much pain and agony due to the compound fracture grade 2 on the right elbow, for which he underwent surgical procedure. So, for the court had granted
No, X-ray of the left,
30,000 is granted, we will grant 40,000.
the X-ray of the left forearm, my lord,
Hmm.
that is one. That is, he states that's also.
Grievous injury is 1.
In the cross-examination, he has denied the suggestions also.
Then how many days he was in hospital?
Forthcoming from my lord. He was from 30, a lot of people get it at page 14 of the judgment. Just about the, from 31/20, for about 1 week, my lord.
1 week.
1 week and follow-up treatment for after that.
Court had granted 10,000.
10,000
that
rupees
is
has been granted.
reasonable. Next, loss of income during later period. Which year is the accident?
After of the year 2012. 2012.
7,000. 21,000. Next,
Pain and suffering.
medical expenses
Medical expenses, my lord,
as it is.
57,000 and odd.
070. Then, loss of income.
During later period.
No, that is loss of income in later period is 21,000.
Yes.
Loss of future income.
7%, I don't know, the doctor has.
Then let's go to that, where is the doctor's evidence?
Doctor's evidence, my lord, is petitioner has lost his future income to the extent of 7% weight.
Where do you get that?
Lordship has kindly turned page 9 of the judgment, last paragraph.
Page 9
of the judgment.
Hmm.
The recent X-ray shows fracture is united. However, the oral evidence of Peter is not supported by any authenticated document to show the disability extent was deposed by him. Considering the nature of injuries, age, and occupation of the petitioner, the tribunal has assessed the disability to the whole body as 7%. Hence, it can be said the petitioner has lost his future income to the extent of 7%, which he has.
How much the court had taken? 7%.
7%.
We will take 8%. 1/3 of it. So, 7,000 into 12 into what is the multiplier?
Multiply his is about 34.
What the court had taken?
Is 34. So that will be about 16 million.
16 into 8 by 100. It comes to 1,07,520. Loss of amenities, any amount is granted?
Parimala?
Loss of amenities.
Loss of amenities and 5,000 rupees. If you grant.
We'll grant 15,000 for loss of amenities. Legal expenses.
I think
10,000.
that covers most of it.
Huh?
I think that covers most of it. I think that covers most of it, I think, Your
Huh.
Lordship.
It comes to 2,60,590.
As against 184.
Huh?
As against 184.
Huh. $1,84,270. The present appeal is filed by the claimant seeking enhancement agreed by the board passed in MEC number 2253 of 2012, dated 2nd December 2013. The claim petition was filed seeking compensation of an amount of rupees 5 lakhs. The tribunal had granted the compensation as per the table given below, that is at paragraph number 13, extracted. This matter, as there is no representation on behalf of the claimant, the matter was directed to be listed under the caption for dismissal today by order dated 8/4/2015. On 13/2/2025 also, there was no representation. 70, as this is an appeal of 2014, this court is not inclined to adjourn the same. And accordingly, the court is proposing to dispose of the same on the merits of the matter. Coming to the pain and suffering, the claimant had sustained one grievous injury and underwent surgery. Hence, this court is inclined to grant 40,000 towards the pain and suffering. Coming to conveyance, food and nourishment and transport and loss and medical expenses, the court had rightly granted the compensation and no interference is called for. Then coming to the income, this accident had taken place in the year 2012, and as there is no other evidence on record, the notional income is taken as 7,000, and considering the fracture and the surgery for 3 months, loss of income during the later period would come to 21,000. Then the loss of future income, the doctor has opined that the disability to the limb is 24 and to the whole body it is 8%. Court without any basis are taken 8%, 7%. Hence this court is taking the disability at 8%. That is 7,000 into 12 into 16 into 8 by 100 is 1,07,520. Towards loss of amenities, this court is granting 15,000. In the light of the law laid down in Mekala versus so-and-so, legal expenses 10,000. Altogether, the claimant is entitled for an amount of rupees 2,60,590. Accordingly, the appeal is partly allowed by enhancing from 1,84,270 to 2,60,590.
Lord, may I make a request? My assistance may be recorded because
The then counsel appearing for the respondent insurance company submits that the court had rightly after recording that with regard to their absence, next learned counsel for the respondent insurance company is present. He submits that the court had considered the evidence on record and rightly granted the compensation, and there are no grounds to enhance. Yes, next. Next.
much obliged.
Cell number 14, A. Hanuman-Sappa for appellant.
For appellant, yesterday it was posted for taking steps to respond number 3, my lord.
Respondent number 3, insurance company, my lord. Any
Respondent
panel,
number 3, who appears?
Sriram is appearing, my lord. Last occasion is not appeared, therefore notice has been issued to the R3, my lord. Any panel advocate director to take notice, my lord, I will serve them.
Which insurance company it
New
is?
India Assurance Company, my lord.
Who appears for the New India Assurance Company?
New India Assurance.
You appear. So and so
K. Srinivas.
is directed to take notice on behalf of the insurance company,
R3.
and he undertakes to file wakalat within a week, and the appeal memo is served on the council.
Serve
List
the
this
copies.
matter, delete from dismissal. List this matter after vacation. Yes, next.
Serial number 15. Rudrappa P for appellant. M.U. Punacha for R5.
So the matter is, as there is no representation on behalf of the appellant on so and so, the matter is directed to be listed in the caption dismissal. Today also there is no representation. Accordingly, the appeal is dismissed for non-prosecution. Yes, next.
Serial number 16. 16. Pramod R for appellant.
Three for the appellant, my lord.
Yes.
It is the owner's appeal, my lord. Where in this case, the liability fixed on the owner.
On the ground?
Liability fixed on the
On the
owner.
ground?
On the ground that, my lord, it is a agriculture policy and the tractor and trailer which was used for the commercial purpose, that is the one ground. And the driver of the vehicle is having the LMB motor vehicle driving license, my lord. That is the two grounds that has been dismissed. You should kindly see in the FIR, it has been clearly stated, in order to construct the farmhouse, my lord, in the land of the owner, my lord, the wooden blocks was taken to that particular place, my lord. Where the wooden blocks were loading, one of the person has been fell down due to the moving of that particular tractor, my lord. That the injury was sustained and he has
Let's
an
come to
accident.
that. Please come to the discussion part.
My lord, you will also kindly see.
Para
the
20 of.
23, my lord. Para 23 is the finding of the trial court.
Read.
On the other hand, it is the version of RW2 ARTO that the separate driving license will be issued to the driver of the tractor and trailer. If the tractor and trailer are being used for the commercial or agriculture purpose, separate driving license will also be issued. As per Exhibit R3, driving license pertaining to the driver of the offending vehicle is not authorized to drive the tractor and trailer, which are being used for the commercial or agriculture purpose. It is to be noted that though the learned counsel for petition has classified RW1 or RW2, nothing has been elicited disbelief there. The evidence of RW1 or RW2 clearly go to show that the driver of the offending vehicle was not authorized to drive the tractor and trailer involved in the accident, and the same is making use for the agriculture purpose. Admittedly, the policy issued in favor of the first respondent owner of the vehicle is the agriculture package policy. When such being the case, the respondent owner of the vehicle has breached the terms and conditions of the insurance policy. Considering the evidence of RW and RW material placed on the record.
So what is the case of the claimant?
The claimant is that, my lord, he was loading the wooden logs in order to take to the land for construction of the farmhouse in the land, my lord. That is the agriculture purpose. That is farmhouse of the owner's land, my lord. That is, in order to construct that particular thing, wooden logs have been taken.
Where do you get such a big discussion on?
That is in FIR, my lord. That is not there, my lord. That is only the fact has been narrated. The group.
See, PW, FIR.
FIR is there, my lord.
Says?
FIR it is clearly stated, my lord. While taking the wooden logs to the construction of the house, farmhouse, at the land of the respondent, that is the appellant, my lord. While loading that particular wooden logs, my lord, it fell down when the tractor was moved by the negligence driving of.
It belongs to the, if the owner is constructing a house.
Farmhouse, my lord, in the land.
Whatever it is.
Yes, ma'am.
When he's constructing a house, if the tractor is used for his purpose, it becomes agriculture purpose.
Yes, my lord. I would like to submit with regard to this, my lord. The farmhouse is being constructed for the purpose of having a facility to put some agriculture materials in that particular house, my lord. In every land, my lord, there is a farmhouse, my lord. That farmhouse is constructed would not be considered as a commercial purpose, my lord. If at all, my lord, if the wooden logs have been taken and wanted to sold some other persons, that would be the commercial purpose, my lord. Here in this case, my lord, the owner himself
For
has,
example, somebody is also, else is also constructing a farmhouse.
yes, ma'am.
They are constructing a farmhouse. For that, you will use this vehicle.
Yes, ma'am.
Then what will it, then it, then
That is
also.
the commercial purpose, my lord. I do agree with that.
Fine.
Why? Because, my lord,
Agriculture purpose, because farmhouse is used for agriculture.
that is, my lord. If the farmhouse is not belongs to the owner, my lord, the question is when the vehicle used for the other than the purpose which has an agriculture purpose, if somebody else is putting the farmhouse,
In the policy, what are the agriculture purpose? What is, how is it defined? You appear for the insurance company.
Yes, madam.
Ah.
It is only for the agriculture, cultivation of land and all.
Oh, that's what, is it any definition for that?
Elaborately, it has been mentioned only for
You have
agriculture.
that note and all, what is agriculture purpose?
My lord, here, my learned friend has left out to point out that the defense entirely taken by the insurance company. Here, the insurance company has also pleaded that the injured was traveling as an authorized passenger in the tractor. That particular defense has been clearly discussed in para number 20 of the judgment. Permitted to read. The second respondent insurance company got examined his senior executive as RW1. He deposed the tractor trailer bearing number so and so was insured with the second respondent insurance company under the agricultural package policy. The said policy was in force as on the date of accident. Said tractor trailer involved in the accident is meant for agricultural purpose only, and the same should not be used for other than the agricultural purpose. The first respondent has willfully breached the terms and conditions of the policy. No premium was received to cover the risk of the employee except the driver. The petitioner was traveling as an unauthorized passenger in the said tractor and trailer.
So
and
even for
injuries.
agriculture purpose also, only the driver is covered as per the policy. Why?
Yes, yes,
If there is a trailer, the loader and unloader will be covered. That's what is the law.
No additional premium has been paid, my lord. That is the reason.
Uh,
As per IMT 28, if they have been paid additional premium, then obviously he would have covered under the policy. Here, we have not received any additional.
So driver
premium.
will only load and unload in a trailer.
More
You
particular.
can understand,
Yes,
it's on the tractor. There is a trailer. If there is a trailer, somebody has to load and unload. They will be covered as per the policy.
My lord, here the petitioner was standing on the wooden logs loaded on the tractor, my lord. Trailer.
that is not the case. That is not.
Your lordship, you may kindly see the cross-examination which clearly reveals that he was standing on the wooden logs which was loaded on the tractor, trailer. ಅಪಘಾತ ದಿನ ತಳಗವಾಡಿ ಹತ್ತಿರ ಮರಗಳನ್ನು ಕಟಾವು ಮಾಡಿ ನಿಂತಿದ್ದೆವು ನಾವು ಜೊತೆಯಲ್ಲಿ ಹಬ್ಬೂರು ನಿವಾಸಿಗಳ ಅಂಕರಾಜು ಮಂಜಾನಾಯಕ ಇದ್ರು ಟ್ರೇಲರ್ ಮೇಲೆ ನಿಂತುಕೊಂಡು ಮರದ ದಿಮ್ಮಿಗಳನ್ನು ಲೋಡ್ ಮಾಡುತ್ತಿದ್ದೆವು. That was the deposition and he was standing on the load of wooden logs, my lord. ನಾನು ಟ್ರೇಲರ್ ಮೇಲೆ ನಿಂತುಕೊಂಡು ಮರದ ದಿಮ್ಮಿಗಳನ್ನು ಲೋಡ್ ಮಾಡುತ್ತಿದ್ದು ಅಂಕರಾಜು ಮತ್ತು ಮಂಜು ನಾಯಕ ಕೆಳಗಿಂದ ಮರಗಳನ್ನು ಕೊಡುತ್ತಾ ಇದ್ದಾಗ ಟ್ರ್ಯಾಕ್ಟರ್
Agriculture trailer.
That is the trailer, my lord. They are loading the things, my lord. They have taken the
Agriculture trailer tractor.
that is not
means,
moving. That is not.
Agriculture tractor means any mechanically propelled four-wheel vehicle designed to work with implements for various field operations or
Yes,
trailers to transport agriculture material.
Yes, ma'am.
Agriculture tractor is a non-transport vehicle. Agriculture trailer means a trailer generally left uncovered with single double axle construction which is coupled into an agriculture tractor. So now what are you transporting are the logs.
Wooden
They are
logs.
for the agriculture purpose.
That is for the construction of a farmhouse in my land.
That is the say of the claimant.
That is my.
If in the cross-examination, he clearly admitted that it was for the selling purpose they are cutting the trees.
And one more submission
Agreed
is
with
that
orders passed in
one more
MBC
submission is that, my lord, it will never comes under the commercial purpose. Because of that, the policy which does not say with regard to that, this would not comes under the commercial purpose. This would comes under the commercial. One more thing, my lord, the other side is submitting that is traveling in the tractor, my lord. That is not traveling in the tractor, my lord, and is just loading the wooden logs, and wherein the tractor was moved and he fell down on the spot itself. He has not moved, my lord. With regard to that submission, my lord, even if it is the land is belongs to the owner, my lord, Paramos is nothing but the part of the.
That you submitted, that I understood.
My lordship, my humble submission is,
Nambisi number.
no material has been placed on record to show that the wooden logs were used for the purpose of the owner constructing the house. And also in the cross examination, he clearly admits that it was for the
Understand, and the
selling
court is
purpose.
with you, why do you want to
Please,
argue?
sorry.
Agree with orders passed in agree with the dismissal law. Agreed with the orders passed in MSC number 114 of 2014 dated 6 March 2015. The owner of the vehicle is before this court. Agreed by the finding that the court that the owner is liable to pay the compensation. The case of the claimant was that on 25/7/2013 at about 5:30 p.m., the claimant was in the process of lowering the wooden logs to the trailer. At that time, the driver of the tractor and trailer all of a sudden moved the tractor in a rash and negligent manner, and the claimant has lost control, fell down from the trailer. Then the wheels of the trailer ran over his left leg, and a result of which he sustained grievous injuries. The tribunal had granted the compensation, and when it comes to the liability, the court has held that it is the owner alone who is liable to pay the compensation. While coming to such conclusion, the court has observed that the driver of the tractor is not authorized to drive a tractor trailer. Further, the policy is given for the agriculture purpose, and the same is used for a non-agriculture purpose to transport the logs, wooden logs. It is a case of the insurance company that he is an authorized passenger and is sitting on the logs in the trailer. The tribunal has observed that there is a violation of terms and conditions of the policy, and the owner alone is liable to pay the compensation. Next part. Land counsel appearing for the owner of the vehicle submits that the tribunal had failed to consider that the tractor is used for agriculture for purpose for constructing the farmhouse tools, and it cannot be termed as a non-agriculture purpose. It is further submitted that the loader and the unloader cannot be termed as a gratuitous passenger. Further, that the LMB transport and non-transport also cannot be a ground for the court to fasten the liability.
Laden weight is laden weight of the tractor and trailer is less than 7.
Is not the ground, and in the light of the law laid down in Mukund Degan, the insurance company is liable to pay the compensation, but not the owner of the vehicle. And counsel appearing for the insurance company submits that all the argument that is put forth before this court was never the case of the owner of the vehicle. He has not placed any material before the court to show that the vehicle is used for the purpose, for the agriculture purpose. He submits that even assuming that the purpose as stated, it cannot be termed as an agriculture purpose, and when there is violation of terms and conditions of the policy, the insurance company is not liable to pay the compensation. Having heard the counsels on either side, produce the material on record. The vehicle is insured for the agriculture purpose, and it is an admitted fact that the vehicle is used for carrying the logs for the construction of a farmhouse. According to the learned counsel for the petitioner appellant, construction of a farmhouse is an agricultural purpose, and the court had failed to appreciate the case of the owner of the vehicle And according to the insurance company, the claimant, the owner of the vehicle has not put forth any material before the court that it was used for the agriculture purpose. This court is not able to appreciate the contention advanced on behalf of the counsel for the owner of the vehicle that construction of a farmhouse is agriculture purpose and there is no violation of the terms and conditions of the policy. In the considered opinion of the court, it does not amount to agriculture purpose and the tribunal has rightly held that the insurance, there is violation of terms and conditions of the policy and the owner alone is liable to pay the compensation. Accordingly, the appeal of the claim, appeal of the owner of the vehicle is dismissed and the amount in deposit shall be forthwith transferred. Yes, next.
Submission, Lord, sorry, my Lord, I was held up in some other court. Case number 15, my Lord, last matter. Lord, I have taken the draft of the paper publication, Lord, but it has not been published in the paper, my Lord. Because of the communication gap, my Lord, I could not contact to the party, my Lord.
So what is to be done now?
I will do, my Lord, kindly extend the time, my Lord, to
Permitted the same, on the same condition, give that date, tell him the dates. He should also know.
5/6, draft
Oblige.
23rd April, hearing on 5/6.
Yes, next. Yes.
Case number 8, Saint Srinivas.
What do you say?
Your Lordship, astonishingly, this case is 73 of 2006. The cause title and the parties are different.
Correct.
No, Your Lordship, kindly see. On the basis of this judgment cannot be passed because the LR of the disease one.
The land counsel for the appellant shall place before this court the order passed in the MBC in respect of the MFA order that the counsel for the appellant is relying on.
The MFA may be due.
No, that record has to be.
Office may be directed to put up the MFA number.
Office is directed to put up the
MFA 5113/2000.
MBC 73.
Judgment
This is directed to put up the.
And also call for the records of that lawyer,
And
73
the
or what?
entire is, yeah, with regard to the said case.
73
Shall be
is to
placed
be.
before, yes,
Okay.
shall be placed before the court. This is matter on 17th of June. Yes, next.
Otherwise, on the
17.
basis of this, judgment cannot be passed.
Yes.
The court will be in a difficult position. ಕಷ್ಟ ಆಗುತ್ತೆ ಇದ್ರ ಮೇಲೆ ಆರ್ಡರ್ ಮಾಡಕ್ಕೆ.
That's what it is posted
Okay.
to June. Yes. Next.
Number 17 adjourned, still number 18. Manjula
Yes.
Devi, Kamadolli, 18.
Hear that? This is an appeal of 2017 and even till now, the notice is not issued to the first, notice to the respondent, even for the first time. Earlier, a cost of ₹500 was imposed and no acknowledgement is filed for having paid the cost of ₹500. And this matter came up on 11/2, there was no representation. Mute that.
Yeah.
1/4/2025. There was no representation. And the matter was directed to be listed for dismissal today. Today also there is no representation. Accordingly dismissed for non-prosecution. Yes,
Number
next.
19, Srinivas BV. Nasimurthy.
Permitted to take out the notice to the respond number 3, my lord, through the paper publication, Vijayawani, Bengaluru edition, my lord.
Which one?
Bengaluru, Vijayawani,
No.
19.
19, my lord.
Where is that? Is it put up?
It is not yet filed.
You are not filed.
Not Pune, is there, my lord.
You are going to
Permit-
file it.
Yes, my lord.
The land council submits that the application for substitute services or they are ready and going to file it. This is matter on 15th. Along with the said application for a substituted service Yes, next.
Cell number 20.
Okay, for the respondent number 1, my lords.
Respondent number 2, my lord.
Respondent number
The
1.
copy is not served, my lord.
Has also representation on behalf of the appellant on 28/3/2025. The matter is directed to be listed today and the caption for dismissal. Today also there is no representation. Accordingly, the appeal is dismissed for non-prosecution.
Cell number 21.
Yes.
Patalli Karelauda. PB
My lord,
Sitaramaya.
kindly pass forward, madam, 21.
No password today. This is matter on 11th of June. Delete from the caption. Dismissal.
Cell number 22. For orders matter, cell number 22.
I served a notice to the counsel who represent the respondent before the trial court. The counsel name is Dilip Dilip. I mentioned it in the memo.
As per the order passed for this court, the learned counsel had taken out notice and served the. That should have been mentioned in the memo. Why you
Yes,
have
madam,
not mentioned?
Yesterday I didn't mention. Yesterday I mentioned it in the memo.
Huh?
Earlier I was not mentioned, but yesterday I mentioned and.
Where is the name?
Dilip case.
Yes, serve the notice on Dilip case, who is appearing for the respondent. Registry is directed to print the name of the counsel. This is matter on 22nd. Interim order earlier granted is extended till. Just look at it. If the interim order is there earlier, extended in all the cases. Yes. Next.
Cell number 23. GJ Mungapur.
Enhancement served to the trial court advocate, my lord.
I'm appearing for the respondent. Yesterday, my lord, I informed to appear, my lord, for the respondent. I yet to receive, my lord, the wakalat and my lord, the.
Land counsel so and so. Please give your right your name.
Yes, please.
So and so submits that he has instructions to file wakalat. List this matter on 28th April. By the time objection shall be filed, interim order earlier granted is extended till then. Next.
Number 24. Shankar Reddy C.
Kindly be passed over. Kindly passed over.
Translated copies are filed or not filed? What is the purpose of?
The counsel for the appellant may read up in portal number 5. Therefore, my lord, I will inform.
List this matter. Finally, on 17th of June.
Please, my lord.
Yes, next.
Cell number 25. 25. Narayanam Nayak.
Yes, memo for acceptance of paper publication. Name is accepted.
Alto Shivakumar.
And notice to respondent number 2 is held sufficient. Then
Delay of 328.
this is a claimant's appeal.
My lord, liability, my lord.
I'm saying, is it a claimant's appeal or
No,
insurance
no.
company's appeal?
Not by the claimant, my lord. Respondent number, as per the claimant, my lord, he hirer of the vehicle, my lord.
I number 1 of 16 is filed to condone the delay of 320 days in filing the appeal. As stated in the accompanying affidavit, the delay is condoned. Admit post of final hearing. Next.
Cell number 26. SV Hegde Munkan.
For the appellant, my lord, notice were taken, my lord, notice were ordered to bring on record the LR of the deceased. My lord, the process has been already furnished. Now the office has.
Furnishing of 3 sets of appeal copy to issue notice to the proposed respondent.
Already, my lord, on notices we have already furnished. Appeal memo I will furnish it.
Do it, that you have to do it.
My lord, the problem is this, my lord.
Finally, a week's time is granted for
2 weeks
complying
time
with the
kindly be
office.
granted because file was misplaced during COVID period in transit.
No, we crossed COVID a long back.
Yes, madam,
So
but now matter is
another a week's time.
10
is
days
granted.
time your lords may kindly.
Then the vacation will intervene. How
No,
will
I
you
will
do?
apply for the certificate copy of this.
Final, within 10 days, the objections shall be complied with, or else the appeal shall stand dismissed in respect to the proposed respondents.
10 days, my lord.
Yes, 10 days. Yes, 27.
27. Vinod Kumar M. Furnishing of PF.
No representation for police matter for dismissal.
Day.
Tomorrow, if not tomorrow, then whatever is the next
Yes,
day.
ma'am.
Yes,
16 people.
yes, 28.
Serial number 28. Ranjay Gowda, Yenda.
For the respondent.
Same, no representation for dismissal.
16. 4.
Yes.
Serial number 29.
Appellant, I am unable to take steps by way of,
No.
I am unable to take steps for substitute service, my lord. Kindly 2 week time is granted. I will file lesser application.
What is the purpose of waiting? Who is R2?
R1 mile, owner mile. There is no insurance policy.
Non-filing of memo
Yes, ma'am. Paper
is
draft.
not taken.
Lord,
He is not able to contact the client. Where is the point of reissuing? List this matter after vacation. Next.
Serial number 30. Serial number 30. Ravi Shankar
Same
Shastri.
memo for acceptance of paper publication, so and so. List, any delay?
No delay, my lord. A claim petition was dismissed. Lordship may admit the appeal and.
Admit post for final hearing. Yes, next.
Serial number 31. B. Pradeep.
Yes.
R2 and 3 are already in record. My admin friend has filed a memo. I'll file the amended appeal memo.
Let's take that. Where is the memo?
I am for the fifth respondent.
The
No
respondent counsel has filed.
representation on behalf of the respondents. List this matter on after vacation. Yes, next. And fifth respondent for the respondent is present. Yes, 32.
Number
My
22.
lord, week's time will be granted in this matter, my lord, I am fine.
Finally, a week's time.
Obliged, my lord.
No further time will be granted for
Serial
taking
number
steps.
33. Akash Kumar.
Appeal for appellant, we have filed an application for recalling the order dated 19/2/2025 regarding dismiss the appeal, present appeal as against the respondent number 5 and 6, my lordship.
Where is the application?
The client were not coming to,
So let it be.
mine.
Let it be. If the clients are not coming, what will you do?
We have made an application for substitute service by way of.
Appeal itself is dismissed against them. Where is the question of substituted service? Unless and until that order is recalled.
Office submission, I will complete right now, ma'am.
Finally, a week's time is granted for complying with the office objections on I number 2 of 2025. Yes.
Serial number
Next.
34. Shivram HC for appellant.
No representation for dismissal.
16/4.
Yes, next.
Serial
35.
number 35.
So petitioners, my lords. My lords, husband's petition, my lords, for transfer of MC petition from Hassan to Bangalore, my lords. My lords, on the ground is that, my lords,
What is this IA 1 of 25 for dispensation not pressed?
for petition copy, my lords, I filed it, my lords, anyways, my lords. Maybe
IA
what-
number 1 of 25 is filed for dispensation.
It's for transfer, my lords, transfer of
No, dispensation of what?
petition copies, my lords.
Petition copy, for filing of the petition copy, and it is stated that now they have filed the same and they are not pressing for the same accordingly. IA number 1 of 25 is closed. Yes.
My lords,
Serial number
my lords, A for stay is also there. my
Hmm.
lords.
From where to where?
Hassan to Bangalore, my lords. It's a husband's petition, my lords.
Filed by husband.
Husband, my lords. My lords, respondent is working in Bangalore, my lords. As I filed annexure B, that work order, my lords, where she is working in Bangalore. Also, my lords, page number 13, my lords.
You and the wife both are in Bangalore.
Bangalore, my lords.
Petition is filed in Hassan.
Hassan, my lords. After I filed it in Bangalore, my lords. They filed in Hassan, my lords.
Land counsel for the petitioner husband submits that both the wife and husband are working in Bangalore, and to harass the husband, the petition is filed at Hassan, and it's difficult for the husband to travel. Considering the same, there shall be stay of all further proceedings in
MC 74 of 2025, my lords. MC 74 of 2025 pending before Hassan, my lords. Principal Judge Hassan.
MC number. There shall be stay of all further proceedings in MC number 74 2025. So and so. Next, the petitioner shall take out hand summons on the counsel appearing for the respondent before the trial court and shall file a memo to that effect by 4th of June. If it is filed, list the matter on 5th, or else the stay granted by this court stands vacated.
Grateful, my lords.
Yes, next 36.
36. Manoj Kumar JY.
My lords.
the matter has to be remanded for not making beneficiary as the party, my lord. My lord, if your
Grant
lordship-
leave.
Please, my lord.
All these cases.
Please, my lords. I duly produced the G3 and the death certificates of the concerned appellants, my lord, original appellant, all these cases.
All these things, how can this court decide?
My lords.
Will say the appeal is, all the issues are open for the court, for the trial court to decide whether you are all the LRs are before the court or not. How that exercise can be taken up by this court now?
My lords, the point is, the original appellants were demised after the disposal of the first appeal, my lord, before filing this appeal. My lord, I filed the appeal. Now the matter has been remanded. The other matters connected for the same, with respect to the same notification has been remanded. If these matters are remanded, then definitely they'll go before the trial court. They'll put up the necessary application. They'll come on record and they'll try with the other cases.
Who will come on record?
My lord, this LRs, my lords. The point of consideration is original appellants were demised after the disposal of the first appeal.
So who are the LRs of that? And all the LRs needs to be on record. How can you alone ask for this?
My lord, I have made the parties here, my lord. I have got the application also separate for the grant. My lord, if your lordship permit me in MSA 174.
Then let us issue notice to all of them.
Notice.
Let us issue notice to all of them.
To be present, my lords.
No. You must have made them as respondents to this appeal.
My lord.
All the LRs.
Please, my lords. But they are the claimants, my lord. The suit has to be, this appeal has to be filed by the LRs, my lord.
Please come to the cause title.
Please. My lord, appellant number 1 in 174, my lords, is the son of late Puttama, my lords. They're all heirs, my lord. Son of, daughter. One is appellant number 6 is the daughter, my lords. 7 is also a daughter, my lord. My lord, Puttama, she demised on 10/12/2018, my lords.
It shows the legal representatives are 15 in number.
My lords, with respect to that G3, I have filed a better, my lord, one of the son was wrongly shown as daughter with a memo dated.
No.
I have filed a memo dated.
All are shown as 15 in number.
My lords,
in your
I'll
case,
clarify.
the appellants are 7 in number.
I'll clarify, my lords. My lords.
I am looking at MSA 174.
Please, my lords, with respect to that.
Come to page 81.
My lord, with respect to that, I have filed a memo of a better G3, my lord, better copy of a G3, memo dated 29/3, my lords.
This is something we are not dealing with the writ petition under 226, sir.
My lord, I
The
apologize,
leaking
my
with
lord.
an appeal.
My lord, in this,
They are bound by certain procedures, sir. Just like that, whatever you say, I can't take it for on the face value of it and allow the applications.
I agree upon, my lords, in this, one of the son was shown as daughter. That's the only mistake, my lords.
My question is, what is that number 15? Everything is in Kannada. I'm not able to understand that. What is this 15? What is the number 15?
My lord, this is a genealogical tree of a family, my lord.
So these are all the surviving heirs of the representatives of that lady.
Not all, my lords. In this, if it in page number 81, my lords.
I'm looking at that.
Please, my lords. Serial number 1 is the father who is demised, late Annabovi. Then the original claimant, my lords. Serial number 2 is late Puttamma. Then comes Yashodamma, my lords. Yashodamma is one of the heir, my lords. She is appellant number 6, my lords.
Oh, from 3 to 15 means how many? 12 in number.
My lords, in this they have added the brother's wife, sister-in-laws were added here, my lord. That's the only reason.
Why they were added?
Lord, for the G3, they are all living together, my lord. So it was shown as a full family tree. With respect to the heirs, all of them are, the names are forthcoming in this G3, my lord. 7 heirs are there. 7 heirs, their names are reflecting in the G3, my lords.
Let's see your affidavit. Where is that?
Lords, it's page 77, my lords, for the application. Sworn by the appellant number 1, my lords.
Where have you said that my mother, so and so, so these are all the children? Where is that description?
My lord, in the para number 3, my lords,
Yes.
state that the appellant Puttama demised on 10/12/2018 and left behind us as
Where
legal
is
heirs.
that? That I'm not, 70?
My lords,
78 page number.
Page number 78. my
20?
lords.
78 para number 3.
Hmm. What happened to your father?
My lord, he was demised late, long back, my lord. The original claimant is the Puttama mother. She demised after the disposal of the first appeal, my lords, before
which,
filing. this.
which document that you have filed before the court shows that who are the legal heirs? Definitely sister-in-law, but brother-in-law are not the legal heirs.
No, my lords. But genealogical tree itself she speaks, my lord. Who are the heirs of the deceased? With respect
No,
to
if any order that is passed by the court granting you leave and and permitting you to prosecute the matter in a way amounts to saying that this court has declared that you are the enlarged of so and so.
no, my lord, because there was this after the conclusion of the proceedings that she was
For that, there
demised.
should be some material before the court.
My lord, for that death certificate is available, my lord. She was demised after the.
Yes, and who are the surviving legal heirs?
With respect to that, I have produced genealogical tree, my lords. They are the surviving. My lord, itself it speaks that they are the legal heirs of the demised claimant, my lords. It's issued by the concerned authority, my lord.
He shows 15 people.
My lord, the genealogical tree expected who are living in the family, my lord. In this, they have shown sister-in-law who are so staying with along with the wife of the brother, my lord.
Whatever that the genealogical tree which you are referring to, file a translated copy of it. Let me understand.
I shall file it, my lord.
Yes. This is matter on 23rd.
Much of
all the 4 matters.
Please, Your Honor.
Cell number 37, for admission 37, Gautam Raghunath for petitioner.
My lords, I appear for the petitioner. My lords, may kindly have this matter passed over, my lords.
No passovers today. List this matter on 24th. Yes, next.
Cell number 38. Cell number 38, Madhu MT.
No representation. This is matter for dismissal
17th.
on not 17th, on 28th. Yes, next.
Cell number 39,
Yes.
Amindech.
For the petitioner. Is a wife petition, my lord, seeking, my lord, a transfer from Bangalore to Kalburgi.
Bangalore to Kalburgi. What are your objections?
Your Honor, in this case, they have, this case is filed in 2021, my lord. And the matter is posted for respondents' evidence now. Already 4 times they have taken time. Now they have come before this honorable court.
How come a 21 matter you moved in 2024?
Yes, my lord. The petitioner is the police constable. Earlier, my lord, she was working, my lord, Bangalore rural. Recently, my lord, she has been transferred to Bidar. Can you take note annexer? See, my lord, page number 50.
So you want transfer from where to where?
Bangalore to Bidar, my lord.
Tomorrow you will be transferred to some other part of Karnataka then?
Then my lord, I belongs to my lord, C group employee, my lord, minimum tenure, my lord, as per the police manual, 7 years. My lord. I have been transferred, my lord, in the year 2023, my lord. That is the reason, my lord, I am seeking for transfer.
What husband is doing?
Husband is working, my lord, in bank.
He is a software engineer, Your Honor. Since from 2021, they have taken hardly 25 dates for cross-examination when she was present in Bangalore itself.
Please, the proceeding sheet.
It is there, Your Honor. They have produced the entire order sheet.
Let us see.
They have not given me the documents, but they have.
Itself, I am producing the entire order sheet.
Entire order sheet is in.
Petitioner present, respondent number 1 absent.
Entire order sheet annexure B, Your Honor. Kindly go through that, Your Honor. Since from 2022 to 2024, they have taken nearly 20 to 25 dates for cross-examination. They have filed 4 times application for recall. And the matter was posted for arguments. Later on, they come with application. Again, they take the date. This is the routine they are doing. And this is the final stage. At this stage, they are asking the transfer.
Yes.
No, my lord, she being a government servant, my lord, I could not able to, my lord, travel from Bidar to Bangalore, my lord. And also, my lord, there was so many proceedings, my lord, pending. Each and other, my lord, case and counter case has been filed. And also, my lord, I prefer the 482 petition.
Why were you proceeding with the matter before the courts at Bidar? Why have you filed these many applications to recall, to further cross-examine? And why should, after spending considerable time by the court, why should the matter be transferred now? You advance arguments, the court will
Only,
hear
my
the
lord,
matter.
based on the annexes.
Will direct the court at Bidar to expediently hear your matter.
Yes.
And you should not file any other applications.
No, my lord. Time may be fixed, my lord. It may be disposed within a short.
Yes. The present petition is filed.
Your Honor, transfer. If the transfer is given, see, before filing the objection, she went to.
No, the court is dismissing their case.
Yes, please.
The present petition is filed. Seeking transfer of episode number 3822/2021 pending on the fine of the principal family judge at Bangalore and transfer the same to the family court at Kalburgi. The petition is filed by the wife. It is stated that the wife is a police constable and she is working in Bidar, and it is difficult for her to attend the case at Bangalore, as such the same has to be transferred to Kalburgi. Land counsel appearing for the respondent submits that the MC is filed in the year 2021, and from there on several applications are filed, several adjournments are sought, and for cross-examination they've taken a lot of time, and also filed applications to recall and to further cross-examine. After filing these many applications, after hearing the matters at length, now at this point of time, they cannot seek transfer of the petition. Next para. Having heard the counsels on either side, petition material on record. This is an MC of the year 2021 and 2021, and a perusal of the order sheet shows that the case is contested by the respondent and contested the same for such a long time. What made her to file this petition in the year 2024 is not known. Hence, it is submitted that as she is transferred to Bidar. Earlier, where you are working?
Bangalore rural, Nelmangla.
Earlier, she was working in Bangalore. As such, now she has not known that Mega, not known, no, that sentence.
Annexure C is there.
Now she is transferred to. Earlier, she was working in Bangalore. Now she is transferred to Bidar. As such, this application is filed, considering the fact that already considerable time is spent by the court on this case, and the matter is coming up for arguments.
Yes, now it is for
cross of
evidence.
So coming up for the cross at this stage, this court is not inclined to transfer the petition. However, balancing the interest of both the parties, the trial court is, the family court is directed to dispose of the MC as expeditiously as possible, but not later than 6 months. And the shall not seek disposal. Yes.
40.
It's transfer petition filed by the wife, my lord, from Hegda Devana Kotte to Bangalore, 200 plus kilometers from Bangalore.
What is which place to which place?
HD Kotte
To
Bangalore, to Bangalore city.
You're filing wakalat. Land counsel so and so submits that is filing wakalat today and seek time for filing objections. List is matter on 28.
Interim order may be extended.
Interim order earlier granted is extended till then. Yes, next.
Serial number 41.
Yes.
Wife's petition, my lord, seeking transfer from Bangalore to Shivamogga, my lord.
Distance?
Distance, my lord, about 275 kilometers.
Yes.
For the respondent in this case, my lord. My lord, I have filed objection in this case, my lord. May I kindly see the objection, my lord.
What is your objection?
My lord, she has given a complaint against me in the Chennagiri Taluk, my lord. And her address is shown in the that FIR is Chennagiri Taluk, my lord, Davangere district, my lord.
According to you, she is not residing in Shivamogga.
No, my lord.
And
I filed memo, my lord, previous date of hearing. Now she is residing in Shivamogga. Your children are studying there, my lord. Studying in the rented house.
Here, where you was, why you was, I mean.
Because Chennagiri is my parents' house.
Davangere is your parents'
Chennagiri is almost 40 kilometers away from the
43
Shivamogga.
kilometers. You are staying with them.
Please, now
you are
my
staying at
Shivamogga. I have produced the Aadhaar card also on rented in a receipt of the.
Yes, please come. The petition is filed seeking transfer of GNWC number 276 of 2023 and MC number 28 of 2024, both pending on the file of the Principal Judge Family Court, Bangalore, to the Family Court at Shivamogga. It is submitted that now she is staying in Shivamogga along with her two children.
Please.
Two children, and the children are also studying at Shivamogga, and the distance between both the places is more than 275 kilometers, and it's difficult for the wife to travel. Land counsel appearing for the respondent submits that. Earlier, a complaint is given by the wife against the husband, in that the address is mentioned as Davangere.
Chennagiri Taluk, Davangere district.
Chennagiri Taluk, Davangere, and he submits that it is difficult for, if the case is transferred from Bangalore to Shivamogga, it's difficult for the husband. Next para. No, in response to that, land counsel submits that earlier she was staying along with the parents. Now she is staying at Shivamogga, and he has also filed the documents to show her place of residence, and the children are studying. Next para, having heard so and so, considering the fact that the wife is at present staying at Shivamogga and the children are studying as to take care of the children, and the distance between the places is 275 kilometers accordingly. So and so. Yes, next.
Serial number 42. Chandana Tariga.
The petitioner, wife's petition. She's at Bangalore with a small child of 4 years, my lord.
2 days time, my lord.
Why accommodation is March of 2024?
I'll just file my objection. Objections are ready, my lord.
Why have you not filed? When did you file your wakalat?
Wakalat, my lord, two hearing dates, my lord.
Then
2 weeks back, my lord.
Let us hear what are the objections could be, then you can tell the court.
Yes, ma'am.
My lord.
You're seeking transfer from where to where?
From Mangalore to Bangalore, my lord.
Bangalore to Bangalore, yes.
The distance is about 360 kilometers. And kindly see annexure A. There is an order by this honorable court in MFA that the father can visit the child at Bangalore every Sunday, and he is doing it. Kindly see page 13. It says it is submitted that the appellant is an employee of the bank in Bangalore, that is myself, and it is fairly admitted that the child is residing with the appellant. That is the observation of this honorable court. In that view of the matter, the visitation.
Yes, I have understood that. Yes.
Rights granted earlier is modified. It is open for the respondent to visit the child whenever the child is residing, wherever the child is residing, and the visitation is permitted on every Sunday between 10 a.m. to 12:30 p.m. Subsequently, there is a further order that he should visit the child at Bangalore and on every Sunday at the KGID premises. That is part of the High Court premises.
Yes.
And he is exercising that order, that right. And the petition is filed at Mangalore for custody of the child. That is in exhibit annexure D. So the wife is residing in Bangalore with that child, and to visit Mangalore for every occasion of the case, it is not possible. It is very difficult. Whereas a husband, the father is visiting the child every Sunday at Bangalore.
My lord, prior to this, my lord, prior to filing of this petition, divorce proceedings were initiated in Mangalore. The divorce petition filed by her dismissed, my lord. She has participated, my lord, throughout in that proceedings in Mangalore. Thereafter, my lord, I filed this petition, my lord, and thereafter, my lord, they contend now, my lord, she has shifted to Bangalore. And therefore, the case has to be transferred. And she has already contested the case from Mangalore, my lord, by filing her objections and.
When did she move to Bangalore?
My lord, before the appeal was filed in the year 2023, in the year
So
2022.
it's the fact that you're exercising the visitation at Bangalore.
Now I'm exercising at Bangalore, my lord.
That's the order
The
passed. in
fact
MFA.
remains, my lord, that was my, I'll file my objections, my lord, 2 days
Who
time.
stopped you from filing in a
It's
2024
late,
petition?
my lord, it's
Why
late.
should the proceedings be stalled?
No.
All,
It's-
I'm wondering
Lord,
how come the CPs of 24,
No,
23
this is
are
only,
still
I
there?
prepared it and sent it to the party, my lord. I'll just file it, my
Does
lord.
this matter on 15th? No further
16,
time?
16, my lord.
16th, no further time?
Yes,
And the orders will be passed based on the material non record.
Interim order may,
Objections are not filed.
interim order may kindly be
Yes,
extended.
next.
Case number 43, Rajashekar.
Transfer it to Bengaluru to Monday, man.
Counsel for the petitioner is present. No representation for the respondent list on 15th. Yes, as part of.
Interim order extended. Interim.
In all the matters wherever interim order is there, it will be extended.
Three, 4 times maybe.
That's why it's posted to part third on 15th. That day, whether he's there or not, orders will be passed.
Case number 44,
No representation for the petitioner. Counsel for the respondent is present. Listed as part third on 15th. Yes.
case number 45,
Applied for petitioner, my lord. Wife has filed seeking transfer from Mysore to Bangalore, my lord, which is approximately 150 kilometers, my lord. And wife has initiated divorce proceedings before Bangalore court. It is pending before 4th additional family court, my lord.
What is filed at
GNWC, my lord.
Mysore?
Mysore, filed
Husband
by,
filed GNWC.
please, my lord.
Hmm.
Admittedly, child is aged about 5 years, my lord. Both husband and wife are working in Bangalore itself, my lord. Bangalore itself, my lord. Child is suffering from initial stage of autism, my lord. Mother is taking care of the child, but mother is residing in Bangalore, my lord. Divorce proceedings are pending before Bangalore court, my lord. I have produced the copy of the divorce petition at Annexure D, page number 17, my lord.
The present petition is filed seeking transfer of MC number,
GNWC, my lord. 70 of
GNWC number
70 of 2024.
70 of 2024, pending on the file of the third additional principal judge, Family Court, Mysore, to the fourth additional principal judge, Family Court at Bangalore, where the petition filed by the wife seeking divorce is pending.
Please.
It is submitted that the distance between both the places is about 275 150 kilometers, and the wife has to take care of a special child, and it's difficult for her to travel. Considering the same, there shall be stay of all further proceedings and summons.
Please.
And the memo shall be filed by 9th. If the memo is filed, listed on 10th, or else the stay granted by this court stands vacated. Next.
July, my lord. 10th.
46,
Yes.
case number 46, Gaurav Subramaniam.
For the petitioner, please.
Vasantappa.
Wife's petition. Seeking transfer from.
We didn't receive any copies from other side, madam. We didn't receive any copies from other side, madam.
I have duly executed the hand summons along with the petition copy to them.
No, we didn't receive any copies.
Personally, I have.
Server. When counsel so-and-so submits that they have recently filed wakalat and they'll file the objections. This is matter on 3rd of June. The interim order earlier granted is extended till then. Next.
47, K. Kumar TM.
Seeking the transfer from Bangalore to Chalkere. In this case.
Go to
Bangalore to Chalkere.
distance.
Distance is 250 kilometers. Chitradurga district, and it is.
I filed objections, my lord.
What are your objections?
So both there is no issues, and both the husband and wife, they are working in Bangalore, and there is no necessity because they are going to these things. But apart from that, much earlier.
What is the material before the court to say that she's working in Bangalore?
Pardon me?
No, the transfer is from Bangalore to some other place.
Bangalore to Chalkere. She is working
Then
in
where?
Empower. She's working in a multinational company, Empower, multinational company in that Sarjapur Road, my lord.
What is your reply to that?
My lord, as on the previously I was working, my lord. Presently I am not working in the
File an
place.
affidavit.
And also, my lord,
File an affidavit.
the
Learned counsel for the respondent submits that the wife is working in Bangalore in a multinational company, which is denied with the
Empower.
learned counsel appearing for the respondent. The wife shall file an affidavit stating that affidavit clearly mentioning till what time she worked in Bangalore and at present what is her occupation.
Yes.
This is matter on 9th of June. Intermod earlier granted is extended till then.
my lord, kindly have short date. This
Short
month.
date. Then list on 28th.
20. Achha.
Till number 48,
Yes, 48.
Appearing for the petitioner, my lords, seeking transfer from Bangalore to Shivamogga, my lord.
Learned counsel for the petition is present, no representation for the respondent. 15th, on 15th as part heard.
till number
List 49.
49.
Intermod earlier granted is extended. Yes.
I appeal for the petition in this case. This is a petition filed by the wife to transfer the case from Bangalore to Tiptur.
Bangalore to?
Tiptur, it is 150 kilometers away from this. I am residing with a small child of 12 years and I'm working in a very small job in a private firm in a small town like Tiptur.
What do you say?
That's matter is of 2016, my lords.
But it was remanded once.
Remanded back.
Because of
Once again, they have
remanded
2019. Then they have filed one civil petition. Same was dismissed for non-prosecution.
I have produced it.
No. A matter that is remanded in 2019. How can you file a petition in 2025?
No, I have filed a criminal miscellaneous petition in 2023 before the Tiptur court against the respondent hearing. Then I have sought this transfer petition now.
Transfer of what?
MC is filed by the respondent before the
Correct.
family
No,
court.
that's what I'm asking. MCs of the year 2016.
Yeah.
That is remanded in 2019. So from 2019 till 2025.
Because of COVID, 2 years has elapsed. Because of COVID,
COVID is like after that's another 3 years.
The reason is this, my lord.
No. Will not transfer. And what is the stage of the suit? MC now?
Evidence, sir. They are not appearing for evidence only.
Not appearing, our advocate has taken time. One submission.
Yes.
The petitioner is working in a very small private firm for a 8,000 mega salary. He is running a medical shop and wholesale business and earning around 15 lakhs.
He will pay the expenses whenever
No,
you're going.
one more thing, in criminal miscellaneous, 15,000 maintenance is granted, 10,000 for me and 5,000 my minor daughter. That also is not paying for last 2 years. Now he is harassing me to come to Bangalore for the case.
You only kept quiet from 2019. Nobody asked you to go there. You had this option in 2019, which you have not exercised. When the court has spent considerable time on the hearing of the case, that's not right on the part of this court to transfer it. Whenever the party realizes that they want to transfer, cases cannot be transferred. At best, what the court can do is, whenever on the each date of your traveling, whatever the expenses the court determined, let him pay. And if you are ready to pay,
he is not paid.
Are you ready to pay the expenses for her travel? Yes. We'll ask the court to determine that.
Directions may be given to conclude within 6 months. 2016 matter is of.
Yes, we'll also direct the court to dispose of the matter. The present petition is filed by the wife seeking transfer of MC number 580 of 2016 pending on the file of the 6th additional principal judge, Family Court, Bangalore, and transfer the same to the senior civil judge in JMFC Tiptur, where criminal miscellaneous 1/2023 is pending, and also to direct the court to dispose of MC and criminal miscellaneous together. Then counsel appearing with the petitioner submits that the wife is residing in Tiptur with a 12-year-old daughter. It is submitted that she is not self-sufficient to maintain herself with the meager amount she's getting from the employment. It is stated that it is difficult for the wife to travel, and the distance is
150 kilometers.
150 kilometers. And it is stated that in the criminal miscellaneous, the maintenance that is granted by the court is not paid by the husband, and is not paid by the husband. Next
Last
para.
2 years, ma'am.
From the last 2 years. Land council appearing for the, why, when you're not paying the maintenance from 2 years, how will you pay the,
Yes, is pending, my lords.
what is pending?
Objection, objection.
There is no order passed.
Order has been passed. They have not filed execution petition. Let them file it. Execution act.
What did you write? Next para. Land council appearing for the respondent submits that the MCs of the year 2016. It was remanded in the year 2019. Right from 2019 till now, they were contesting the matter, and suddenly now they have come up with an application for transfer, and it cannot be transferred at this point of time. Next para. It is submitted that if the wife is ready to bear the expenses whenever she appears before the court for the transfer, and what requisite expenses whenever she attends the court at where is this?
Bangalore.
Whenever she attends the court at Bangalore. Next para. Having got the counsels on either side, produce material on record. This court can understand the difficulties that are put forth before the court for traveling and the distance between the places. But the fact remains is that the MCs of the year 2016, and earlier the matter was remanded in 2019. Till 2019 to 2025, no steps are taken by the wife seeking transfer, and having submitted herself to the jurisdiction of the court, and the court having spent a considerable time on this case. At this point of time, on the reasons that are stated by the wife, the petition cannot be transferred. Whenever, and this court is not inclined to transfer the petition. However, whenever the wife travels, the husband shall pay the expenses for her travel, stay. The trial court shall determine the amount that needs to be paid to the wife. Accordingly, the petition is allowed, and all these clauses in the operative portion, and the court shall determine. The trial court, the family court shall dispose of this matter as expeditiously as possible, but not later than 6 months.
Once it was remanded in 2020, not 19.
Not 19, 20, remanded in 2020.
Number 50, PR Balraj.
For the petitioner.
Yes.
The wife's petition, my lord, seeking transfer of the divorce petition filed by the husband from Bangalore to Mysore, my lord, because she is residing at Mysore, and the Domestic Violence Act and the maintenance petition filed by the wife, which are pending before the family court at Mysore, my lord.
The present petition is for seeking transfer of the MC filed by the husband from Bangalore to Mysore. It is submitted that the wife is residing at Mysore, and two other cases, one under the Domestic Violence Acts and the other under the 125 CRPC, are pending before the family courts at Mysore. Considering the submission and the distance between both the places is 150 kilometers. They are considering the submission of the land council and the difficulties put forth. They shall be stay of all further proceedings. Hand summons. The memo shall be filed by 9th. If the memo is filed, list on 10th, or else the stay granted by this court stands vacated.
Number 51.
So the wife's petition, my lords, transfer from Bangalore to Davangere, my lords, which is 280 kilometers, my lords, 6 hours drive, my lords.
For some time to file the objections, my lord.
When did you file your wakalat?
7.
Stays there.
Stays there, my lords.
Then council appearing with the respondent seeks time for filing objections. List this matter on 3rd of June. The interim order granted earlier is extended till then. Yes, next.
52. Shriyar.
I appear for the respondent in this matter. My lords, I may be permitted to file my statement of objection today. Mainly call this matter by next week.
My lord, I have sought for stay in this case, my lord. This is a petition for transfer from Bangalore to Shimoga, my lord. Petitioners are permanent residents of Shimoga, my lord, and the distance is about 300 kilometers. My lord, already the divorce case filed by the...
Take that objections, we'll hear it on 15th.
My lord,
it is
meanwhile, stay may
what
be
meanwhile? What is tomorrow? List this matter.
On 16th,
on 16th, the petitioner shall serve the objections on the council for the respondent. The matter will be finally heard on that day. Yes, next 53.
53. YP,
Milord 53, Milord,
Venkata
appellant's
Pati.
counsel is on the way, Milord. He says he is stuck in the traffic. It may kindly be passed over, Milord. He comes. He's on the way, Milord.
No passover. Let's this matter on
Please.
22nd.
Cell number 54 adjourned. Cell number 55.
From 55 to 60
3.
till the end of the list, till 70. From 64 to end of the list. Will be, they'll all be given dates because court is not taking up the final hearings of 18.
Serial number 57.
No, right from 58 is also there. That is CP, no? So we'll hear the CP. So 59, call 59, 60, 61, 62, 63, till 63. From 64 to the end of the list, give the dates.
55, your lordship may kindly see. My crop is also pending, my lord.
I'll hear till 63. 58 to 63 will hear. From 64 to the end of the list, give the dates. Call the list. Yes.
55, my lord, my crop is pending. That is not posted.
55?
Yes, the
list along with the cross objection.
MFA number
Yes,
39.
next. Yes, next.
Cell number 50. 58.
Yes, 58.
Cell number 58.
57. Kindly pass over the matter. There's some urgency.
MS. Oh, it's a fresh matter.
Yes, my lord.
Passover, 57 passover. 57 passover. Yes.
The petition
Yes,
are seeking
58.
to transfer the MC petition filed by the divorce petition filed by the husband in Mandya to Bangalore. Two petitions are pending before the Bangalore Family Court, the 6th additional family court.
Why it is posted for final hearing? CP? You're seeking transfer from?
Mandya to Bangalore. Another two cases filed by the petitioner. One is restitution of conjugal rights. Another one is a maintenance case. Both are pending before the 6th additional family judge. Bangalore.
Yes. The present petition is filed seeking transfer of MC number 34 of 2021 pending on the file of the principal senior civil judge and CJM Mandya to the 6th additional family court at Bangalore. It is submitted that the marriage was solemnized on 15/11/2018. In view of the disturbances between the parties, the husband had filed MC number 34 of 2022 on 2/2/2021.
My lord, 56 is not called, my lord. 56.
That is adjourned to
56.
This is also a fresh matter.
This is a fresh matter. I appear for respondent.
No, I thought then 56 and 57 pass over.
Pass over, my lord. Yes.
Yes. No, MC is filed in the year 2021. When was the stay granted?
Stay granted on in the 2024.
What was the stage at that time?
Presently hearing on IA and under section 24.
What did you write? All of them, let them stand here. Here, all of them stand here and take the dictation. They're not able to connect when I'm calling them. The husband had filed MC number 34 of 2021 seeking a dissolution of marriage on 2/2/2021. It is stated that the wife had already initiated the proceedings under the Domestic Violence Act.
Criminal miscellaneous maintenance.
Criminal miscellaneous and?
Number 158 of 2023. And restitution of conjugal rights.
And the wife had filed restitution of conjugal rights on the file of the family court at
6th additional. 6th additional family.
Bangalore.
Bangalore.
had filed the proceedings on the file of the 6th Additional Family Court at Bangalore, and also the proceedings under 125 CRPC are initiated. It is submitted that the distance between both the places is about 150 kilometers and is difficult for the wife to travel. Next para, though notice is served on the respondent, no wakalat is filed. Considering the fact that already 2 cases are pending at the family court at Bangalore and the distance between both the places is 150 kilometers, this court deems it appropriate to allow the petition accordingly. Yes, next.
Cell number 59. 59, M. Anil Kumar.
Where is he? No representation for the appellant. List this matter after vacation. Yes, next.
Number 60.
60 also respondent, madam.
Same.
Yes.
This also after vacation.
Cell
Yes.
number 61. D. Vijay Kumar for appellant. GV.
Also after vacation.
Cell number 62.
After vacation.
Cell number 63.
After vacation.
Passed over cell number 56.
What is 56?
It is passed over. Somebody asked.
Only one matter passed over.
2.
Oh. If they are there, 56 and
56 K. Shashikant Prasad. Chandana Tarika.
We'll take up afternoon.
Yes.
Call the other list.
Yes, ma'am.
Kind
Number 2.
List number 3, one matter Milords we have arrived at.
List number 3.
Serial number 61 Milords.
Serial number
61. Milords, the date of accident is of the year 16.
No, what is the amount?
Milords, if the escalation of 7,000 is added, Milords, it will come to 15,13,400. He's
That amount is agreeable. No. If you are both of you have agreed, then we have agreed at that amount, then otherwise we will call the list.
He is agreed only with the 7,000 escalation. Otherwise, of 7,000.
But that we will see in the core, while dealing with other matters also, not out of the way. Yes.
Cell number 53, Your Honor, second list.
23 second list.
Second list, 4,15,000, including interest.
Both the council submits that they have agreed that the insurance company has agreed to pay an amount of rupees.
4,15,000.
4,15,000, and they will come up with a joint memo.
Then matter is their amount to be released, Your Honor. Date of action 2017, my lord.
In that you can that memo you have to file first.
Their amount to be released.
Yes. Next.
List number 2, serial number 1.
Appearing for the appellant, my lord. Therefore, week's time to take fresh steps to respond number 1, my lord. Because liability is on the respond number who is the owner of the vehicle, my lord.
Liability is on the owner. You the file.
R1 is the owner.
United India.
United India. Where are the officers? United India Insurance Company.
Gomesh Farato.
I appear.
Come to the front.
I appear for R1.
Why the liability is fixed on the owner of the vehicle?
82,500, my lord.
Huh?
82,500.
What is that?
82,500.
Why the liability is fixed on the owner?
That is because the vehicle was not registered at the time of accident, my lord. Hence the liability was fixed on the owner of the vehicle, my lord.
Yes, Mr. Krishna Kishore.
But it is connected with MFA.
Let there be a judicial order.
Yes. Delete from the list. Yes. After vacation.
Or appeal is also there. He's
Cell
giving
number
another
2.
number.
Second appeal is also same, my lord. In that, my lord, one filing memo, my lord.
Take that list along with that number. Yes, next.
Serial number 2. Keshav Bhatia.
APF for second respondent.
That's serial number 2, my lord. I am filing memo, my lord. That appellant number, sorry, respondent number 1 is track record
Said for compliance of office objections.
and
Serial number 3.
Have you seen this? Three.
Serial number 3. S.C. Vilshubendraya.
It's a case of death. 9,20,948 is given.
They have come up with the calculation. They have come up with the calculation to what extent we can enhance.
That's
Actually,
what
deceased age is 50 years.
we'll calculate. What is the age of the deceased?
50 years.
Income, how much taken?
Taken 5,000.
Which year is the accident?
2010.
2010.
Supposed to be 5,500.
5,500 should be taken. Multiplier is suspects.
Actually, they have taken.
So 5,500. That's 1375.
6,870.
25 into 12 into
6,875.
but it is coming lesser than that.
Yes, ma'am.
Why?
Because they have taken future prospectus 30% there.
And but the salary is taken less.
Yes.
Salary is taken at
5,000.
it will come down. It'll
Yeah.
be less only if it is calculated.
Only there. It seems that they have gone for consortium, I think.
Consortium.
But other heads they have given more.
Now what happens is now even how many are the dependents? Huh?
Three dependents. 1/3 deduction correct. It comes less only. This much only it will come.
No. It's a wrong calculation. 5,000. 375. Six, 8, 7, 5. How many are the dependents?
3. Rent.
4583 into it will be enhanced. It comes to 7,15,000.
But
7,15,000. 4,583 into 12 into 13. Then 3 into generally for the court grants 3 into 44.
Okay.
It comes to 1,32,000. Then funeral expenses 36,000. It comes to 8,83,000 without legal expenses.
Tribunal awarded 920.
9,20,000.
9,20,000 because there are so many heads.
Yes.
Who appears for the appellant?
Serial number 3, Your Lordship.
Serial number?
3.
Appellate, Your Lordship.
Huh?
Appear for appellant, Your Lordship. I'm sorry, Your Lordship.
No, you better withdraw this appeal. Liability is on the insurance company. Now the
I
calculation.
seek instruction from senior, Your Lordship. Kindly pass over.
Pass over.
Please, Lordship.
Then number 4.
Yes.
Then number 4.
What about this? Case of death or injury?
Injury.
There is no table. How many are the injuries?
2 injuries.
No, fracture of both.
2
bones
are
of
grievous
left leg.
injuries.
Yes, ma'am.
Pain and suffering.
Party is granted.
60,000. Then what is the income according to them?
8,000.
Which year?
2015.
Court had taken 8,000.
8. Yes.
2015 it is supposed to be 9,000.
9,000.
For how many months later period amount is given?
Only 1 month given.
So we'll take 3 months. 3 into 9. 27,000. Then
Medical expenses.
disability?
32,000.
No disability.
No, 1,63,200 is granted.
On account of permanent disability.
Down.
You had opined that in view of the bone grafting of fracture of tibia and so and so, with permanent disability of 63% to his both lower limbs. Percentage disability given is on the higher side, even on the event of the whole body will not come to 63%. Record either in deposition, so and so. 10% is on the lower side.
16%. 16%.
So it's, let's say if it is, we'll take 20%. 20?
20%.
Then future loss of income. So it is 9,000 into 12. What is the multiplier?
17.
17 into 20.
3,67,200.
3,67,000. Three lakh 67,200. Then loss of amenities. How much is granted?
8,000 is granted.
30,000. Loss of amenities. Then how many days was in hospital?
7 days.
How much the court had you are granted?
No, 32,000 is granted.
8,000 only grant. Where is that?
It is 8,000.
Amenities 8,000.
Not amenities. With regard to this transport, nourishment and all.
Incidental not given.
Not given. Food nourishment, conveyance.
Food nourishment. We'll grant 10,000. It's coming to 4,94,200. Because that loss of that itself is 3,67,200.
No, minus 1,63,000.
What is minus 1 lakh?
Already given.
Granted under
No,
disability.
that I am not calculating. It is a fresh head, everything.
Reassessment.
Yeah, inclusive, not above. It comes to 4,94,000 against
440.
4,40,000. No representation. On behalf of the appellant, counsel for the insurance company is present. List this matter on 15. All these matters wherever calculated, pin it.
Lord, in respect of United India,
Mm.
they have come up with the calculations.
Uh-huh.
They have come up with the calculations.
Uh.
One of us will assist them. Only thing is claimant advocate has to come.
No,
In every case, there is a calculation.
no. Anyhow, we cannot either ask insurance company or the claimant advocates to be present. They will come if they want to come. So we have made the calculation.
Even in local, if they could come, we can.
They're not coming. That's the whole difficulty. That's what even your officers are expressing. From morning to evening, they're staying and nobody is turning up. So now this calculation is made. If they come tomorrow, it's fine. If they don't come in the same calculation, I'll dispose it off. All these things on the first page, you just pin it up. No representation for the respondent. List this matter as parted on 15th, 12 o'clock. 12, at 12 o'clock. Yes, next.
Cell number 5. Cell number
Five.
5. Ravi Shankar CR.
This is the accident itself is disputed and acquitted.
This for the insurance
Yes,
company.
insurance.
Delete from the list after vacation. Yes, next.
Cell number 6.
Business income is produced, my lord, after
Uh-huh.
vacation. Business income is produced after vacation, my lord.
After vacation. Yes.
Cell
No
number
for
7.
disposition to notice to R2.
Hmm?
No for disposition.
Memo is filed seeking dispensation of notice to so and so. Same, taken on record and dispensed.
Needful is done, DL issue.
Which one?
7, serial number.
Cell number 7.
It is submitted that the needful is done. Next.
Cell number 8.
Ravi Shankar, Ravi Kumar NR.
And for the appellant, in this case, I am.
You are the
filing
claimant.
Filing a memo for the dispensation of the notice to the respondent number 1.
A memo is filed seeking dispensation of notice to R1.
R1.
R2 is?
R2 is the insurance company.
S5 Shivali is the counsel for insurance company. Which is the insurance company?
It's the Oriental Insurance.
Huh?
Oriental Insurance Company.
Who appears for Oriental?
Orient.
You appear. Officers are not there.
Yes,
Officers are not there.
officer not yet come.
This is matter after vacation.
Yes.
Yes, 9.
Cell number 9.
I
Authorized.
for the appellant in this
inter-alia.
case, my lord. Praise for week time, my lord. And
IN number 1 of 24 is filed to condone the delay of 77 days in filing the petition. The same is considering the reasons stated condoned. This is marked admit post for final hearing. Yes, next.
Cell number 10.
In this case, as
So,
a business
Kumar
income is produced, my lord. Business income is produced.
No.
No, already produced, my lord, after vacation, my lord.
Yes, after vacation.
After notice
Yes.
notice R1 may be discussed. Notice R1 may be discussed.
Not R1, R2.
R2.
Say memo is filed seeking dispensation of notice to R2 dispense with. Same as the risk of appellant. Yes, 11.
Cell number 11.
Admit post for final hearing. Yes.
Liability issues next.
Delete.
Both, two cases are.
2 cases, delete from the list. Yes, next.
Cell number 13. Cell number 13. Pramodar.
Yes, CR Ravi Shankar. Please be here whenever your cases are there in the list. You're going for the next case. Yes. What about this?
This is
Password.
password, but next afternoon.
13.
13.
13. Officials also not come.
Pramodar.
You are for the petitioner.
My colleague is there, madam. Kindly pass out
Password.
Password, but next
after vacation.
after
Why?
because I have to discuss and this one.
No, if both of you are not interested, then what the court can do? This is matter after vacation.
Cell number 14. KV Satish.
Grievous injury, 2 injuries.
Yes. Oriental Insurance Company.
Oriental
This also. Where is Mr. Ashok and Patil? I number 1 of 18 is filed to condone the delay of 150 days says in so and so. Delay condoned without condition. Next. Admit post for final hearing.
Serial number 15. Jacob Shetty.
Yes.
I have made a calculation. In case of injury, court has taken 24% disability.
What is the evidence of the doctor?
Pardon?
Evidence of the doctor.
Evidence, based on the evidence of the doctor, only 24% disability
As it
was
is,
taken.
it's taken.
Please. 5,000 income was considered.
It should have been.
They said that 15,000 working as a contractor, but court has taken 5,000. As on the 25/20/2014 is the date of accident, therefore 8,500 has to be taken.
So 8,500 into 12, what is the multiplier?
14.
Into? 24.
Please.
It comes to 3,47,720.
Please.
Pain and suffering?
50,000 is granted.
How many are the injuries?
3, maxillary, zygomatic, maxillary, and metatarsal bone fracture.
60,000 then?
Medical expenses 1,52,600.
1,52,600.
52,600. Food, conveyance, nourishment. He was hospitalized for 7 days. 4,000 grant.
Then 10,000.
Yes.
Nourishment and transport.
Loss of later period, only 1 month is granted, 5,000.
3 into 8,500.
Please.
How much?
25,000.
500.
Amenities 10,000 it is granted.
We grant 30,000.
Future medical expenses granted up.
How much is granted?
Future treatment, not up. Medical expenses, 75,000 it is granted.
What is the evidence of the doctor?
Doctor says that, but
He said 75.
he says 1 lakh, but court has said.
Yes, the amount.
It comes to 7,820,000. How much was granted?
4,64,600.
670?
4,64,600.
600. No representation for the appellant. Heard the land counsel for the insurance company. List this matter tomorrow. No, tomorrow is on 15th. In that, all wherever the calculations are made, that is one list. Oh, that should be the first list. Yes, next. 16.
Serial number 16. 16.
16.
Serial
Yes.
number
16.
Chetan B.
The tribunal has taken, my lordship, 5,000, my lordship. In the
Case of death or injury?
injury, my lordship. At the time of the injury, he is aged about 32 years, my lordship.
32
years. He is working as an agriculturist, my lordship. Earning 20,000 rupees.
According to him. Court had taken 5,000.
5,000 rupees, my
How
lordship.
much it should be?
8,500, my lordship.
Then
Is an
disability?
Disability 100%, my lordship.
Head injury.
Head injury.
And 100% disability.
100%. 40% future
The
perspective.
prospects
Please.
40%. So 8,500. Comes to 3,400. What is a multiplier?
16.
16, huh? 16.
It comes to 22,84,800. Correct?
Yes.
Then what about the other heads?
My lordship, regarding my lordship, attendance charges, my lordship, is an 100% full disability. It's
Then
lifelong.
In the judgment, where how the
Please.
100% disability,
Has been awarded.
how much is awarded?
My lordship, food nourishment,
1 lakh.
attendance charges, including all to 1
In
lakh
cases
rupees.
of 100% disability, if
Please.
they want to have, they need a complete attendance.
Attendance,
In
please.
the other judgments in Kajal and other things, the Supreme Court has calculated it is almost, it comes to the same amount. Huh? So what is the reasonable amount?
My lordship,
Court had granted 1
lakh rupees.
1 lakh.
Yes, ma'am.
Another 2 lakhs.
Okay.
Another 2 lakhs.
Another
2 lakhs.
No, my lordship. Lifelong, one person need to look after himself. He's till 2 days and
That
bedridden.
case we'll hear it on because this calculation won't work out.
Please.
Because they also can't accept for this.
Please.
This is matter after vacation. Yes, next.
And the usual course, madam.
Huh?
Usual course, madam. Usual course.
1 of 18 is filed to condone the delay of 20 days in filing, condone, admit, file hearing. Yes, 17.
Cell number 17.
Yes, Ravi Shankar Shastri.
Case of death, my lord. The income was assessed to
Who
5,000
is the
per
respondent insurance company?
B.A. Ramakrishna. B.A. Ramakrishna.
Company.
United in India.
United India Insurance Company.
United.
18/3/2016 is the date of accident, my lord. The claimants are wife, 2 minor children, and parents, my lord. 5
5 in number.
5 in number. Wife was made as a respondent in the claim petition. Now, present appeal is by the wife and 2 minor children, my lord. The MACT reckons the income at 5,000 per month, my lord, as against the claimed income of rupees 20,000 per month.
And how much it should be in 2016? 9,500.
My lord, as per legal service authority, 9,500, my lord. Future prospect was not considered.
Age is?
Age was 24 years, my lord.
So future prospects at 40%.
Yes, my lord. That is for
It comes to 3,800.
Please, my lord.
How much has to be deducted?
My lord, MACT has deducted 1/5, my lord. It should be
File is there?
1/4, my lord. There are 5 dependents. 9,500 into 12 into 18 into 3/4, my lord, it will come to
13,300.
Please, my lord.
It was here only.
300. 1/4.
1/4.
1/4.
Into.
It was here.
Comes to 3,325. Into 12, multiplier is?
18, my lord.
Into? It is coming to 21,54,600.
600. Please. Then, my lord, under conventional head, there are 5 dependents, my lord. Wife, 2 minor children, and parents.
No, it has to be in the Lok Adalat.
Please, my lord.
Whatever is, how it is, the conventional heads are granted how much?
40 per head. my lord.
Per head.
Other 2 are 15, 15, 30.
Like 40?
General 30, 50. Then
No. It's like now we say that 40 into 5.
40 into 5.
Then 2 lakhs.
2 lakhs. Loss of estate 15 and funeral 15. my lord.
30.
Then medical expenses 50,222 awarded by MACT.
50,000?
222.
222. It comes to 24,34,822.
As against award of 9,89,222, my lord.
220?
9,89,222.
Balance. So a joint memo can be filed. Both the council, it is submitted that the insurance company has agreed to pay an amount of rupees 24,34,822, and they'll file a joint memo.
Interest, my lord.
6%.
Yes.
The interest is 6%.
Just actually, they have to leave for 2 years from date of petition till date. So
What is
normally during Lok Adalats, 2 years.
Whatever that applies for Lok Adalat, let that be followed.
My lord, I had a case on income also, my lord. Some evidence was led. Therefore, my lord, 1 year's interest we will, my lord, negotiate.
Yes. Because they have a norms for compromise.
But my lord, in case of injuries or my lord, where the enhancement is interest, when enhancement is more than 15 lakhs, my lord, if you leave the 2 years interest, my lord, it will be more than 2 to 3 lakhs, my lord. That is where we are finding it difficult in case of death, my lord.
2 years.
Even death injury, both cases we do.
The 2 years interest part, it is submitted that they will file the joint memo. When to be listed this matter?
There is one more difficulty, my lord, in this case. The parents are the respondents, my lord. Therefore, court order may be necessary because, my lord, I cannot, my lord, since they are not parties to as appellant, we cannot settle in the Adalat, my lord, because apportionment will be them too also, my lord. Therefore, court order may be necessary.
Then we'll pass an order in this. Pass an order. This we'll list this on Friday for passing orders.
Tuesday.
Tuesday.
Please.
That all that wherever calculation is done, it should be on the first page so that the court will understand. Yes, next.
Serial number 18, Rupesh B. 18, Rupesh B for petition appellant.
Which company?
And party.
This also National Insurance Company.
No, claimant. Ashok and Patil for R1. He is the insurance.
National Insurance Company is the respondent. Give that. Is this matter for final hearing in the usual course? Yes, next.
Serial number 19.
This 19. This also same. This will have it after lunch.
Yes, ma'am.
20, could it be, my lord, final hearing, my lord, after vacation? Serial number 20.
Serial number?
20, my lord, next case.
Why?
Lord, party intends to take court order, my lord, not in the other.
This is matter after vacation.
Lordship. Serial number 21 also, my lord. They have challenged the liability. 21. Connected matters are there.
Thirdly,
Yes.
serial number 61, my lord.
Thirdly,
Serial number 61.
He is agreeable for that.
Which is that? We'll record it in the afternoon. Yes.
Judicial order.
He
Judicial
wants
order.
the judicial order, my lords. That may be passed.
It's reasonable.
If it is a judicial order, why should we take it out of turn? It will come on its own.
It may be listed on that. Any day where it will be.
We'll see.
Question number 3.
Because I should take.
Sir, Nagraj ekte. Ravi, me or either claimant.
Court officer. Court officer. Court officer. Court officer. Court officer. Court officer.
ಅವ್ರು ಬೇಕು ಅಂತ ಆನ್ಸರೇ ಮಾಡ್ತಾ ಇಲ್ಲ. Hello, madam.
ಹೇಳಿ ಸರ್.
ಅಲ್ಲ ಮೇಡಮ್ ಈಗ ಥರ್ಡ್ ಲಿಸ್ಟ್
ಸರ್
ಅದೇನು
ಹೇಳಿ.
ರೆಫರ್ ಟು ಈ ಥರ್ಡ್ ಲಿಸ್ಟ್ ರೆಫರ್ ಟು ಲೋಕಾಯುಕ್ತ ಆಗೋದು ಅಥವಾ ಏನು ಅದು ಅರ್ಥನೇ ಆಗ್ತಾ ಇಲ್ಲ ನಮ್ಗೆ.
ಸರ್ ಇಲ್ಲ, ಅದು ಈಚ್ ಇಂಡಿವಿಜುವಲ್ ಕೇಸ್ ಆಗುತ್ತೆ ಅನ್ಸುತ್ತೆ. ಯಾಕೆಂದ್ರೆ ಸಮ್ ಆಫ್ ದಮ್ ಆರ್ ನಾಟ್ ವಿಲ್ಲಿಂಗ್ ಟು ರೆಫರ್ ಟು ಲೋಕ್ ಅದಾಲತ್.
ಅಲ್ಲ ಕನ್ನಡದಲ್ಲಿ ಹೇಳಿ, ನಮ್ಗೆ ಇಂಗ್ಲಿಷ್ ಅಷ್ಟು ಅರ್ಥ ಆಗೋದಿಲ್ಲ.
ಲಿಸ್ಟ್ 2 ಕಂಪ್ಲೀಟ್ ಆದ್ಮೇಲೆ ಲಿಸ್ಟ್ 3 ಕಂಟಿನ್ಯೂ ಆಗುತ್ತೆ.
ಮೇಡಮ್
ನೋಟ್ ಅಲ್ಲೇ ಹೇಳಿದಾರಲ್ಲ.
ಮೇಡಮ್ ಲಿಸ್ಟ್ ನಂಬರ್ 1 ಅಲ್ಲಿ 55 ಏನಾಯ್ತಮ್ಮ? 55. ಹಲೋ ಮೇಡಮ್, ಕೋರ್ಟ್ ಆಫೀಸರ್.
ನಂಬರ್ 1 ಅಲ್ಲಿ
55.
ಮೇಡಮ್ ಕೇಳಿಸ್ತಾ ಇದೆ? ಒಂದ್ ನಿಮಿಷ, ನೀವ್ ಹೇಳಿದ್ನ ನಾನು ನೋಡಕ್ಕಾದ್ರೂ ಅವಕಾಶ ಕೊಡ್ಬೇಕು ನೀವು.
ಓಕೆ ಅಮ್ಮ.
ಸೀರಿಯಲ್ ನಂಬರ್ 55.
ಹೌದು.
ಒಂದ್ ನಿಮಿಷ ವೇಟ್ ಮಾಡಿ. 55 ಅಲಾಂಗ್ ವಿತ್ ಅವ್ರದ್ದು ಯಾವ್ದೋ ಇದಿದೆ, ಕ್ರಾಬ್ ಇದೆ ಅಂತ ಸಬ್ಮಿಟ್ ಮಾಡಿದ್ದಾರೆ. ಕ್ರಾಬ್ ಅಲಾಂಗ್ ವಿತ್ ಅಂತ ಆರ್ಡರ್
301/17.
ಹೌದು. ಏನ್ ಹೇಳಿ, ಕ್ರಾಬ್ ನಂಬರ್ ಹೇಳಿ. ಅವ್ರು ಕ್ರಾಬ್ ನಂಬರೇ ಕೊಟ್ಟಿಲ್ಲ ಇನ್ನು.
301/17.
301 ಅದೇ ಅಲಾಂಗ್ ವಿತ್ ಅಂತ ಆರ್ಡರ್ ಆಗಿದೆ.
ಓಕೆ, ಥ್ಯಾಂಕ್ ಯು.
Court officer? Court officer? Court officer?
ಡಿ ವಿಜಯ ಕುಮಾರ್ ಸರ್ ಹೇಳ್ಬೇಕು ಏನ್ ಬೇಕು ಸರ್? ಹಲೋ ಡಿ ವಿಜಯ ಕುಮಾರ್ ಸರ್. ಹೌದೇ ಮನೆ ಬಿಟ್ಟು ಆಚೆ ಹೋಗ್ಬೋದು. ಅವರೆಲ್ಲ ಒಬ್ಬರಿ ಹೋಮ ಇರ್ಬೇಕು.
One submission.
Pass
madam.
over.
One submission. We have given the list of company appeals as well as the claimant appeal regarding withdrawal, liability aspect, as that we have given the list to the Adalat also. We are give company it can be disposed of.
Those matters, take it and list on 16th and 17th.
Another melod, serial number, list number 3, serial number 107. It is settled for 1,80,000.
1 minute. Which one?
107, serial number, list number 3. Matter pertains to Sriram General.
Then council
for 1,80,000
respondent,
in addition.
both the council submits that the matter is settled and the insurance company has agreed to pay an amount of rupees.
1,80,000 in addition to what?
80,000 in addition or?
In addition to what has been
In addition to
granted.
what has been granted by the tribunal, and they'll come up with a joint memo.
Please, my name may be shown for the insurance.
For the respondent company, Mr. Shivanagowda.
BC Shivanagowda.
BC Shivanagowda.
My lord, serial number, list 3, serial number 30.
Uh-huh.
List 3, serial number 30, my lord, kindly refer to Lok Adalat on 16th, my lord. Already I talked to them.
Here also, that is what is
Please,
happening.
please, no problem. I talked
No,
to
no,
the
let
company
it
people.
in the list.
Please, please.
Call the source in the morning.
List number 1, list number 1, serial number 56, Shashikant Prasad.
Not here for the petitioner.
Huh?
Allowed. See.
Yes.
I may be permitted
Serial
to.
number?
I may be permitted to represent the council, my lords. It's only on the short point time before my lords.
1 minute.
56, my lords.
MSA.
MSA. Only on short point time before my lords. Only on the basis of admission made by the defendant, my lords. Suit is one for admittedly for ejectment. So the defendants have admitted that, my lords, they are the tenants. They have made the statement before the court, my lords, while filing objections to one IA, stating that, my lords, we don't have any objections to vacate the premises. However, my lords, the plaintiff has demanded, my lords, 6 lakh rupees to be payable by the defendants. On that basis, my lords, the trial court says, my lords, so now since you have admitted the relationship and you have stated that, my lords, you don't have any objections to vacate the premises, my lords, trial court decreed the suit, my lords, by invoking order 12 rule 6. As against that, my lords, they preferred appeal. The appellate court now says, my
On
lords,
what ground they prefer the appeal?
they preferred that, my lords, so there is a dispute with regard to, my lords, the eligibility of the plaintiff to file the suit or his locus standi to file the suit. They contended that, my lords,
It was not their case in the written statement.
it was not their case, my lords. Now my respectful submission is, my lords. Now when they say that, my lords are well aware, my lords, if there is a dispute amongst the landlords, my lords, that cannot be that cannot inure to the benefit of the defendants, who are, my lords, seeking for ejectment. Now here is a case where, my lords,
Please come to the
yes,
appellate court's order.
please, my lords. Page number starts from, my lords, page 11, my lord, 10, my lords. Reasoning is at, my lords, page 20. Kindly go to, my lords, page 21. Page 21. Internal page 12 of appellate court order. Paragraph number 9, my lords. Starts from para 8. I may be permitted to read from para 8, my lords. Learned counsel for the appellants defendants mainly argued that when the locus standi of so and so is seriously disputed, trial court ought not have decreed the suit on the basis of the admissions statement. My lords, got it. The suit in itself was not maintainable. The trial court erred in concluding that there is an admission to hand over possession to Bhaskar Kattemar as the defendants did not intend to do so. The trial court was wrong in rendering the judgment, only hearing on the application filed under Order 11 Rule 1 to 4 and 8 read with Section 151 of CPC. The learned counsel for the respondent argued that as per Order 12 Rule 6 of CPC, the judgment can be pronounced on admissions. When the admissions have been made by the parties in pleadings or otherwise, whether orally or in writing, the court may pass a judgment as it thinks fit, having regards to such admissions. Thus, the trial court is justified in passing the judgment impugned in this appeal. Having regards so and so, my lords, next, the first appellate court relies upon one decision. Then, my lords, kindly go to paragraph number 11, my lords. By the ratio laid down herein, it is certain that Order 12 Rule 6 of CPC, though provides for judgment on admissions, it is an enabling provision which is not mandatory but discretionary. The court on examination of facts and circumstances must exercise its judicial discretion, keeping in mind that a judgment on admission is a judgment without trial, which permanently denies any remedy to the defendant by way of an appeal on merits. This rule cannot be claimed as a matter of right, as this is only enabling provision. Thus, courts cannot employ this provision where vexed and complicated questions or issues of law had arisen on such questions has to be determined categorically. In context of this suit, though trial court having considered the statement made by defendants in the objections filed to IS so at para number 5 stating that the defendants were ready and willing to give up possession to defendant of door number so, but Bhaskar, yes. Now, my lords, I'll pause here, my lords. This is their contention. They, on one hand, my lords, they contend that this Bhaskar Kattemar has no locus. On the other,
come to the original suit.
Yes, please, my lords. Kindly turn to page 35. Reasoning is at, my lords, page 45. Paragraph number 47, my lords. Page 46, internal page 12, my lords.
But there are only 19 paragraphs.
Page 46, paragraph number 11, my lords.
46.
Page 46. Trial court judgment. Internal page 12, my lords.
No, the trial court judgment starts at, there are two page numbers, 35, 53.
35 is, my lords, it starts from page 35.
No, beneath that, there is another number, 53.
My lords, maybe.
Yes.
There, my lords, internal, I may be permitted to refer to internal page, my lords.
Oh, better.
Kindly go to, my lords, page, internal page 12. Paragraph number 11, my lords. Except the above said facts, the defendants have not stated anything new.
No.
In other words,
No, we'll start from 10 itself.
Please. Since these issues are interlinked with each other, to avoid repetition of facts, they are taken up together for common discussion. My lords, before that, my lords, may I request my lords to kindly see what is the issue, my lords. Kindly go to, my lords, internal page number 7, my lords. Whether the plaintiff proves that the defendant were the monthly rental tenants under him on monthly rental of rupees so and so, whether the plaintiff proves that he has issued a quit notice calling upon the defendants to surrender the vacant possession of the suit scheduled property. Now, my lords, the reasons are, my lords, since these issues are interlinked with each other, to avoid repetition of facts, they are taken up together for common discussion. Before considering the point number 1, that is whether the suit can be decreed partly based on the statement made by defendants in their objections to IA number 9, as prayed by the plaintiffs, it is just and necessary to say some of the important facts of the case. The plaintiff has specifically alleged in the plaint that the defendants are monthly rental tenants under the plaintiffs and monthly rental of rupees 40 per month. The said fact is admitted by third defendant in invoice number so and so. It is further pleaded by the plaintiff that the defendants have illegally sublet this scheduled premises to third party on rent basis. It is further alleged, taking advantage of mismanagement of the plaintiff Basadi, the defendants were not regular in payment of rent. The defendants had been paying monthly rent during 1990s through Vijay Bank of the plaintiff Basadi. Thereafter, as per order in invoice number so and so, the defendants were keep on depositing the rent in the said suit only. On the other hand, though the defendants have denied the above said facts formally, but they have not denied the same specifically. In other words, they have not explained how they came into possession of the suit scheduled premises. They have specifically pleaded that the plaintiff has no right to file the suit and he has also no authority to issue quit notice and to ask mean profit as paid in the plaint. The judgment and decree in OS number so and so is not valid or binding. It is also specifically pleaded that the sister of the representative of the plaintiff has
So
filed.
even it is a case that they have specifically pleaded that plaintiff has no right to file the suit. That's a case from the beginning.
Yes. Now, my lords, now kindly see, my lords, next paragraph number 12 also, my lords. At this stage, it is also necessary to say that it is not the case of the defendants that the Basadi is managing by Bhaskar S. Kattemar at present. In fact, they have specifically stated in their written statement that the sister of Bhaskar S. Kattemar has filed civil suit before the principal civil judge and so for seeking possession of Basadi and management from Bhaskar S. Kattemar. In view of the said clear admission in the written statement, it is clear that Bhaskar S. Kattemar is managing the plaintiff Basadi.
What is Basadi means?
Basadi means,
Temple,
my lords,
my lord.
temple. It's a
Amongst
temple where, my lords, more particularly Jains, my lords, worship. Lords. Once it is admitted that Bhaskar Kattemar is managing the plaintiff Basadi, he has every right to terminate the tenancy.
It is filed in his individual name or in the name of the
Lords, it is filed in the name of Basadi.
Presented by the administrator.
Administrator. Now he is the administrator. Now kindly, my lords, allow me to read further. Once it is admitted that Bhaskar S. Kattemar is managing the plaintiff Basadi, he has every right to terminate the tenancy. From the above said facts, it is clear that the defendants were monthly tenants for a month for the rent of rupees so and so per month for the scheduled premises. The defendants have also admitted that the plaintiff issued notice for calling upon them to vacate the scheduled premises. When they say that the plaintiff has no authority to issue notice, and also they say that Shri Bhaskar S. Kattemar has been managing the plaintiff Basadi, the question of saying that the plaintiff has no right to issue notice does not arise. Hence, the managing trustee, Bhaskar Kattemar, has validly terminated the tenancy by issuing notice so and so, so and so. Now, next, I'll skip para 13, my lords, kindly go to para 14. It is alleged in the plaint that the plaintiff is intending to build a community hall in the place where the scheduled premises is situated after demolishing the same. The government is also willing to donate rupees 50 lakhs for construction of community hall under the development of minority scheme. No doubt the defendants have specifically denied the above said contentions of the plaintiff. But in the objections to IA number 9 at para 5, it is specifically stated by the defendants that it is submitted that the defendants were ready and willing to give up possession of door number so and so. But Bhaskar S. Kattemar insisted that the defendants should pay rupees 6 lakhs as mean profit in addition to surrendering the premises. From the above said admission, it is clear that the defendants are ready to vacate the scheduled premises subject to the plaintiff should not ask mean profit. Now, the question arises whether, in view of the above said pleadings, whether the suit can be decreed. There, my lords, Order 12, Rule 6 is incorporated. Then, my lords, by placing reliance on so and so. Kindly see, my lords, internal page 16. From the above said provision, it is clear that a decree can be drawn based on the admission made by the defendants or in the evidence or in applications or in objections, even on an oral admission. On this point, the Honorable Supreme Court of India has also held, which is reported in AIR 2006 SC 2628, that if the defendants admits neither in the evidence or in the pleadings that they are ready to vacate the premises, the court need not go further inquiry and pass decree on the admissions itself. In AIR 1995 SCW 3927, it is also held by the Supreme Court of India that in the written statement, certain admissions were made in regard to the claim of the plaintiffs. Then the court can pass a decree. In the present case, the defendants have specifically admitted that they are ready to hand over vacant possession of the scheduled premises. As stated herein above, it is well established principles that if the party to the proceedings have made some admissions in the written statement or objections to in other IA or by way of applications or orally, the suit may be decreed on the very same admission. And the defendants are ready and willing to hand over scheduled premises to the plaintiff. The question of going further for investigating whether the plaintiff has right or not, or whether the defendants are bound to vacate and deliver the vacant premises of the scheduled property to the plaintiffs are not necessary. Therefore, without much discussion, it is just necessary to say that the plaintiff is entitled for decree of possession in view of admissions made by the defendant. On this score, my lords, the trial court has decreed the suit. However, my lords, insofar as mean profit claimed by the plaintiffs, there is no finding insofar as, my lords, that aspect of the matter is concerned. Now, the first appellate court only on the ground that, my lords, since there is a dispute with regard to locus standi of, my lords, the...
Yes, how are you aggrieved by the said judgment and decree?
Yes, my lord, kindly come to the appellate court judgment.
Yes, I have read the judgment.
Yes, that the paragraph 11.
Yes.
Paragraph 11 at internal page 14.
Yes.
By the ratio laid down there in the judgment of 2011-15 SCC, my lord. By the ratio laid down there, it is certain that Order 12 Rule 6 of CPC.
No, that I understand.
Yes.
When a suit can be disposed of in the light of an admission, that is what is discussed.
Admission.
No,
Yes.
no, suit is for the
Possession.
Eviction.
Yes, eviction and mean profits.
Mean profits.
Yes.
Now it is your case that you accept that you were ready to give possession of the property, but he was asking for mean profits,
Yes.
which you were not ready for.
Yes.
What relief he is seeking for eviction, you are ready for that.
My lord, it should be an admission in the pleading. Application is not a pleading. Kindly see Order 6 Rule
No,
1.
according to you, any admission in the pleading is not a pleading at all.
No, in the pleading is an admission. If it is a pleading.
No, if something is said in an application,
Yes.
by way of an affidavit,
Or objections.
that is not that is not a pleading.
That is not a pleading, is so first submission. For that, would your lordship kindly see Order 6 Rule 1.
So parties are not bound by their own admissions.
No, admission should be under Section 58 of the Evidence Act. That is what the First Appellate Court has said. First Appellate Court has gone into this aspect and said that this statement in the objection is not unequivocal. It does not amount an admission under Section 58 of the Evidence Act, and it is not in the pleading. Now, would your lordship kindly see Order 6 Rule 1 for a minute and Order 6 Rule 1.
Then who asked you to make such a admission?
My lord, a statement is made.
No, it is purely, we are on technicalities. Let's not go into the provision for before that. Your client has said something that he's ready. Now somebody wants possession, you are ready to give possession. So why should the court do all the activities?
No, my lord, the court need to go into that aspect and give a finding.
When there is no dispute, there is no dispute on that.
My lord, kindly permit me to say this, which is available on.
You can understand the technical aspects of what?
No, legality of this, my lord. Legality of this.
Before telling the court the legality of it,
yes,
please tell the court what is your admission? Why did you make such admission?
My lord,
what is the implication of it? We'll go into that later.
My lord, yes, my lord. My lord, I don't have copy of the IA number 10, which is filed, and the objections to it. Kindly have it on the 16th or 15th.
Yes.
Which, yes. And my lord, my submission would be this. My lord, pleading is defined under Order 6 Rule 1. The plaint and the written statement. In the written statement, there is no such a pleading that I will give back possession. From that premise, I would travel further, and it is my endeavor to satisfy my law on this. Yes.
Yes.
Further
hearing. This is matter. Yes. This is matter for further hearing on
16th or 17th.
On 23rd.
Please.
On 24th.
23rd.
Please.
Yes.
Chair number 57, Mahesh Arupin, appellant.
Plaintiff's second appeal. Suit is for declaration and possession. Declaration is that the document dated 20th May 1975 was a mortgage deed and it is not a safe deed. to evidence that, my lord, on the same day, the defendant, my lord, has executed an agreement, same dated, agreeing to execute separate sale deed on payment of the amount that was paid, my lord, on 20th May 1975. That is the case of the plaintiffs, my lord. Trial court, my lord, decreed the suit. Matter was carried to appellate court. Appellate court, my lord, dismissed the appeal. RSA was filed by defendants. During course of hearing, it was brought to the notice of the court that, my lord, one of the appellant, my lord, died during pendency of the appeal itself. Therefore, my lord, matter has to go back to the first appellate. Matter was sent back to the LRs. LRs were brought on record. Thereafter, my lord, matter was the lower appellate court, my lord, ink page 26, my lord. One of the only reason is this, my lord. One of the document, my lord, exhibit stamp duty and penalty, and liberty was given to both the parties to lead additional evidence. This kind of order, my lord, cannot be passed under part 1 to 36. My lord, ink page 26, my lord. On a perusal of the oral and documentary evidence on record and impugned judgment and decree of the trial court, it appeared that the plaintiff has examined one of the attesting witnesses to the alleged mortgage deed dated 25/1975 as PW2, but PWD has not tendered for cross-examination due to his death. The plaintiff has not examined any other witness to prove the deed dated 20th May 1975 is mortgage deed. In the absence of evidence of attesting witness or scribe of the document, the trial court has held that deed dated 20th May 75, that is Exhibit P3, is mortgage deed solely based on the opinion of fingerprint expert, that is CW1. The trial court has got marked unregistered agreement dated 20th May 75 as Exhibit P4. The said agreement was prepared on stamp of ₹4, which is insufficient. But the trial court has marked the said agreement without importing the same. Therefore, the trial court was in total error in holding that
counsel for the appellant, it shall be stay of all proceedings. In OS number 243 of 1994. In the next date of hearing, petitioner, the registry is directed to issue notice. This matter on 17th of June. Yes. Next.
List number 2, serial number 3.
List number
2, serial number 3.
is passed over.
Yes, ma'am. List number 2, serial number.
Chief, I seek adjournment for Tuesday.
Huh?
I seek adjournment for Tuesday, Lord Chief.
Mohammed Tahir.
No adjournment.
Lord Chief, I'll
No.
get instructions from the client.
No, we have made the calculation in the morning. It's not a case for enhancement. Already enough amount is given by the court. You have to be dismissed. That's why it is adjourned. Huh?
I'll pass over.
How many passovers? Morning it is passed over. Ask him to come. Even if he's not, by the time 4:15, I will dismiss it.
Please.
Yes. Next.
List continued. List number 2, serial number 22. Serial number 22, Marigowda.
Yes. Where are the insurance counsels?
That is MS Sriram.
Where are the officers? They left.
R2.
Which insurance company has come today? Huh? Where is he? Which insurance company it is? Let's see.
Oriental Insurance.
Oriental Insurance, who is, nobody has come.
Oriental Insurance Company.
No, at least counsel should be present. Where is this Mr. Sriram? Give it. No representation on behalf of either of the parties. Let's this matter for final hearing in due course. Yes,
Serial number 25.
23.
23 schedule.
Settled. Yes. 24.
24. R. Shashidhara.
Injury case, Malad.
The case of injury or death.
Injury, ma'am.
Come.
Madam, data, accident 2016 fracture of biomandibular malad. That MSCT taken disability 11% malad. But
What is the doctor's evidence?
PW2 malad.
What is the evidence? What did he say?
He say malad the disability
17% he has stated, 11%
whole body.
Whole body is
17%.
17%.
70. Then what is the income?
Malad, 9,500 should have been taken, Malad, instead of 7,500. 2016 is the accident.
No, court had taken 9,500.
No, after I taken 7,500 taken.
What is the multiplier?
14.
14 malad. 14.
It comes to 2,71,320. Loss of earning during laid up period. $9,500 into 3. 28,500. Loss of amenities, how much is granted?
Loss of amenities malad 10,000.
30,000. Medical expenses?
Medical expenses 1,39,000. 25,000.
That could be retained.
How many days he was in hospital?
8 days.
Huh?
8 days.
8 days.
Yes.
That also need not be enhanced.
Yes.
Future medical expenses, according to the doctor, how much?
Not specifically stated, but 20,000 is taken, Malad. That is. And the loss of income during later period, another 4,000 should be added because of 9,000.
That's what, 9,500 into 3. 828,500.
Malad, the doctor assessed malad future medical is 1 lakh.
It comes to 5,49,820 and the court had granted 3,54,000. Yes. Then counsel, both the counsels of the insurance company is ready to pay, agreed for an 20 and file a joint memo in that regard. Take this.
The Interest was
6%.
9%.
6%. Interest. Joint memo. 15th. All these joint memos and calculation done on 15th in the second. Yes. Yes, 25.
For the respondent.
Appear for the respondent. It's already done. It's also in the first list. That day I'll dictate the order. It's already calculation. Yes, 26.
Cell number 26. Pick up or below.
Case of death, my lords. Case of death.
They're appearing for
Claims.
For the
claimant.
second.
It's a case of death. Age
70 years.
10.
70.
Husband and three married and the bigger sons are the claimants.
70 years. Income
Well considered 2,500.
2,500.
which year?
2015.
2015.
What is the age of the daughters and the dependents?
Settling stood 46 years.
What is the evidence say that they are dependent on them?
No.
77 years. Second appellant is
Daughter.
58 years, 56 years, 54 years, 52 years. How can they be dependent on him?
Therefore,
We'll
tribunal,
consider only wife. What did the court do?
tribunal deducted 50%.
Why?
Husband alone is the legal representative.
Somebody is there. It's not 1/3.
So Pranay Sethi, it is 1/3.
So we have to take the income how much?
9,000. 9,000.
9,000.
9,000.
So no future prospects. In that 1/3 has to be deducted.
6,000.
It is 6,000. 6,000 into 12 into how much?
Into 5. Into 5.
5 multiplier.
Multiplier is 5, your lordship. 3,40,000.
3,60,000. So consortium. So how many are there? 1, 2, 3, 4, 5. 5 into 4. 2 lakhs. Funeral expenses, how much is given?
15,000.
My lord, conventional heads all given 30,000 rupees.
Not there. Generally in Lok Adalat 30,000.
15.
It comes to 5,90,000. How much is granted?
1,05,000.
1 lakh?
5,000.
20,000.
1,05,000.
1,05,000.
5,000. Then council, both the council submit that the insurance company has agreed for an amount of rupees 5,90,000 and they'll come up with a joint memo. Yes, next. All that, the joint memo on 15th. Not on 15th, but I've posted on 16th. Joint memo and other calculations that are done on 15th. Yes. Yes. 27.
Cell number 27. Cell number 27, Puttaswamy C. Already
Done. Let it come on 15th first list.
Yes.
Yes, 28.
Cell number 28. 28.
Nankajappa
MG.
Case of injury, madam.
Who appears for the respondent?
That is
SV Sudhakar Reddy for R2. Which company? Which company?
New India Insurance.
You appear? Where is he? Yes, he was there in the morning. That is United India Insurance. They have not turned up today. Why? Yesterday they were saying that they will come.
They are also doing some list exercise and they are doing list.
Already what is listed, they should complete the exercise on this instead of doing another exercise. Yes, this is smarter in the usual course. 29.
After vacation.
Hmm.
Cell number 29. Vinay Kirtiyam,
Which is the insurance company?
that is
Paying for respondent, that's oriented insurance. My poster before
Yes.
court, ma'am.
Due course.
after
Yes.
vacation. Cell number 30, Nagaraj HR. Cell number 30, Nagaraj HR.
This also.
This calculation.
Calculation. I'll let it come on. Yes.
Cell number 31. 31, Harish, Harsha SP.
Calculation is done. Hmm. This also on 15.
Yes. Cell number 32.
I'm appearing for the respondent, my lord.
It's a case of death, my lords.
Hmm.
Accident is of the year 2010.
2000?
10.
Hmm.
The deceased was 33 years, my lords. The tribunal has taken the income of 4,000. It's
It should have been
5,500.
so 5,500. 40% future prospects.
Please, my lords. 2,200.
Huh?
2,200 is the 40%.
2,200. 7,700 into 12 into
16 into
no,
50,
no, no,
50%.
50% has to be deducted.
Is bachelor
7,700.
by 2 into 12 into 16.
Three 3,850 into 12 into 16. It comes to 7,39,000.
No, my lords.
200.
7 lakh 200
Correct.
200. Yes.
plus convention.
Who are the dependents?
Only one sister that she is.
Sister.
One.
Consortium, the 40,000. Funeral expenses, 30,000. It comes to 8,09,200.
Please,
What was awarded?
4 lakh 4,000.
4,04,000. Same, both the councils are pressed so in some amount, and they'll come up with the joint.
And my rate of interest is 6%, my lord.
Huh?
Rate of
interest 6%. Yes.
Much obliged.
16.4.
Yes.
Cell number
Yes, 33.
30.
Appearing for the respondent number 2, Oriental Insurance.
Case of death or injury.
Alive.
Huh?
Death alive. Hello.
It is a case of death or injury.
Injury.
Let it come.
Yesterday settled.
Let it come on 15. Yes, 34.
15.4. Cell number 34. Anil Shekhar.
Need judicial order because we challenge the medical expenses.
It's all calculation done. Yesterday, the calculation is done. It is coming to 10,56,001. It's already calculation is done yesterday. That's why for filing a joint memo, that calculation is made. I think you were not there yesterday.
Not there.
The office of the jury, they were there. It comes to, court has granted 9,55,701, tribunal. Now after calculation, it is coming to 10,56,001.
Dispute also dispute the medical bill of 11 lakh rupees 28,000. That has not been considered. They only considered 5 lakh 80,000. That has been.
You want it, this has to be, no. Remove that. The list is smarter after vacation.
Cell number 35. Cell number 35. Nivedita N.
Done.
No.
List is smarter. Where is Mr. Janardhan Reddy?
Janardhan Reddy for respondent.
No, it could be some, we could have completed the calculation.
Yes,
This is smart after vacation, no representation. Yes.
Cell number 36. VN Madhava Reddy.
Who appears as the respondent?
MU Punacha.
Which is the company?
United India.
Morning he was here.
MU 19.
He's here now in the court.
I have not seen now. Morning they have present.
Case of death or injury?
Case of death, my lord, regarding the income tax, I have produced the exhibit P 1618.
With regard to the income?
Consider that 1,60,000, but average is come back 1,83,000 rupees per annum. My lord. Regarding that.
Post for a hearing, final hearing. Yes, next.
Next week, date, any date. My
No,
lord.
next week.
Only regarding that income tax. My lord.
2018, it will not be given next week. Next 37, after vacation.
Current, my lord. It has to be dismissed, my lord. Case of injury. But
After
Suresh,
vacation, sir.
please.
36.
Next 38.
38. Balraj AC.
United Indian.
Srinivas.
It's a case of,
Case of injury, my lords.
where are they?
Srinivas R.
Yes, post for final hearing. No representation for the insurance company.
Cell number 39.
Yes, final hearing.
Appear for third respondent.
No representation for the appellant. Yes, next.
Cell number 40. Cell number 40. Calculation is done.
Calculation done tomorrow. That's what, 15th.
15.
Yes,
Cell number 41. Calculation is done.
calculation is done tomorrow.
15.
15th.
Cell number 42.
42 is already over, I think.
32. Shastri G.
25% contributory negligence was attributed to the deceased. My lord.
Oh, 42 after vacation. Yes, 43.
43. 43. Punacha MU.
I think this is insurance company's appeal.
Mm.
Let it come in the list for final hearing.
After vacation. Okay, after vacation.
Yes.
Cell number 44.
I appear for the.
I appear for first respondent, my lords.
Banu HM.
You appear for?
First respondent.
First respondent is?
Transport. Vehicle of the owner.
Owner of the vehicle.
Owner of the vehicle.
Where is the appellant?
44.
Yes, that's for final hearing. Yes, next.
45.
Appearing for appellant, my lord, in this case. Death case, my lord. Case of death.
United India Insurance, B.A. Ramakrishna.
Kumar P.
After vacation, no representation for the insurance company. Next
number
matter
46.
also,
46.
after vacation.
After. Cell number 47.
Both cases for claimant's injury case, right? We, D. Vijay Kumar and I discussed about these cases, my lord. We are discussing for 40,000 for first case and 50,000 for second case, my lord. D. Vijay Kumar is appearing for Reliance Company.
This 47 and 47.1. 47, Mr.
47 is one discussed for 40,000 and 47.1 is discussed for 50,000.
Pradeep is directed to take notice on behalf of the respondents. This is matter for final hearing. Yes, 48.
Cell number 48.
In this case, they have not served the appeal memo.
Open
Maybe have it on Monday. We will verify the record and we will submit.
Wednesday.
Please, please.
Yes. That is,
Cell number 49.
yes,
Cell number 49. Nayak NR.
after vacation.
Cell number 50. Sandeep Katti.
United Insurance Company.
Nobody is here.
B.A. Ramakrishna,
After vacation, no representation for the insurance company.
cell number 51, Vasantappa,
Yes.
C.R. Ravi Shankar,
No representation for the insurance company. Counsel for the applicant is present. After vacation. Yes.
case number 3, one minute, constable.
Let's see later. Complete.
Case number 3, cell number 1, Revana Siddhappa, HK,
How can this be listed? No, not even notices are not served on the respondents.
they have listed.
The the application for substitute service shall be filed by the petty appellant within 2 weeks, or else by not 2 weeks, by 9th of June, or else the appeal shall stand dismissed against the appeal shall stand dismissed. Next.
Cell number 2, S. Krishna Kishore, furnishing of paper to all 2000.
Actually, my lords, they paid the entire amount and I withdraw the amount, claimant.
No.
Something is there, let him submit.
The liability is disputed.
No, first of all, what is this? R2 is a necessary party. Then what happened? Notice to him.
I will take
The non-depositing of 50% of the amount.
it is deposited.
Deposited. It is
Oh,
submitted
withdrawn
that
also.
the appellant has deposited the amount, and he will take steps for service of notice on R2 by June 2nd, or else the appeal shall stand dismissed. Next.
My lord, I am for appellant in this case. It is a owner's appeal. My lord, in the first, my lord, 2/6.
This is matter after vacation.
Cell number 4, Sridhar DS, steps to be taken in R2 since it.
Counsel, my lord, which have taken up after it. In the meantime, my lord.
The steps shall be taken by June 3rd, or else the appeal shall stand dismissed. Yes,
Cell
next.
number 5,
I appear for third respondent.
No representation for the appellant. The amended cost writer shall be filed by 9th of June, or else the appeal shall stand dismissed.
cell number 6, Nayak Ramachandra,
For the appellant, the second time the steps to be given to the first respondent, and Rayal Sundar with us as a point served, which is not represented. B. Pradeep may be directed to take notice for Rayal Sundar.
Mr. Ravi S. Sampratish is directed to take notice on behalf of the respondent insurance company. Then counsel for the appellant shall serve the copy of the appeal memo on the counsel. This is matter after vacation.
Please.
Yes, next.
7, Natarajas Jain,
For second time.
Mr. B.C. Shivanagoda is directed to take notice on behalf of the respondent insurance company. Then counsel for the appellant shall serve the copy of the appeal memo after vacation.
cell number 8, cell number 8,
After vacation.
cell number 9,
My lord,
Shripadvi,
my lord, R1 is Reliance, my lord, in both the cases. And R2 is owner of the vehicle, not necessary. I took the dispensation in 7026. So any advocate may kindly be taken.
Reliance General.
Mr. B. Pradeep is directed to take notice on behalf of the respondent insurance company in 9 and 9.1. This is matter after vacation. Yes.
Cell number 10,
Memo is filed seeking dispensation of notice to R. Name is on record. Notice to R2 is dispensed with. R1 is Nation Insurance Company.
Demon blood for amount.
sir, OMS sir, ನಿಮ್ಮ ಆಫೀಸ್ ತುಂಬಾ ಡಿಸ್ಟರ್ಬೆನ್ಸ್ ಟು ದ ಪ್ರೊಸೀಡಿಂಗ್ಸ್. the compliance of office objection and Rajneesh Iyer one copy.
Mr. S. Krishna Kishore is directed to take notice
S.
on
Krishna
behalf
Kishore.
of the insurance company.
Yes.
Same appeal memo shall be served on the council
After
after vacation. Yes.
number 11.
I appear for appellant. Memo filed for dispensation of notice to first respondent.
Memo is filed seeking dispensation of notice to the respondent number 1, same dispensed with after vacation. Yes, next.
Serial number 12.
This case, insurance company appeal, challenging on the two ground. There is no permit and fitness on the date of accident. Pain recovery has to be added. Another point, my lord, the doctor has assessed the disability of 33%. Entire 33% disability has taken and granted the compensation. Therefore, I am before.
No representation on behalf of the respondents. Who is R2?
One of the vehicle.
Why are you know, you can't seek dispensation.
Also, Sherry.
I will
Mrs.
take-
Marta,
After
after vacation. Yes.
serial number.
Next, no, memo is filed seeking dispensation of notice to R2. Dispense with. Next.
Serial number 14. 14. R. Shashidhara. Publishing of cover
R2
acknowledgement
is
for all.
insurance company, my lord, Bharati AXA.
What is this?
R2 is insurance company, my lord. Bharati AXA General Insurance Company.
Bharati AXA.
AXA.
Now it is ICICI.
ICICI Lombard. Mr. Shivanagowda is directed to take notice on behalf of the insurance company. IA number 1 of 2018 is filed to condone the delay of 160 days. Condone, admit, post for final hearing. Delay is condoned. Next 15.
Serial number 15.
Memo is filed seeking dispensation of notice to R2 dispensed with. Next is Cholamandala.
Amandal.
Mr. H.S. Lingaraj is directed to take notice. Then counsel the appellant shall serve the copy of the appeal memo on the council. IA number 1 of 18 for 24 days condoned. Yes, next.
Serial number 16.
I pick for R3.
Harish Bandari.
Memo for dispensation of R1 and 2.
Memo is filed seeking dispensation of notice
Just ex parte.
to R2. Same is taken on record and dispensed with. Yes. What is this case of death or injury?
Injury, your worship.
Yes, you're ready?
Next date, after vacation.
Post after vacation. Yes, next.
Serial number 18. 17. Serial number 17. Jacob.
What is this magma HDA general insurance? There is one, you appear. So for R2, Mr. BC Sarnagowda is directed to take notice.
After vacation.
Yes.
Serial number 18. KL Srinivas.
I'm appearing for the
K.
respondent.
Krishna Swamy.
So second time,
Padmini.
R1.
Ah.
Step shall be taken in respect to service of notice to R1 by 10th of June, or else the appeal shall stand dismissed against the said respondent.
Serial number 19. Ravi Kumar NR.
I'm filing in memo for dispensation of notice to R1 and R2. This memo filing for the dispensation of notice to R1 and R2.
So memo for dispensation of R1 and R2 dispensed with 2018 appeal. Admit post for final hearing.
Yes, ma'am.
Yes.
Serial number 20.
I'm appealing for the appellant, my lord. I will take the substitute service for the R1 to
It is submitted that they'll file an application for substituted service by.
Is already filed, my lord.
You already filed.
Yes, ma'am.
When
Today
did you
morning.
file? Huh?
Today morning I filed.
They are filing it. List is smarter on 29th. Yes, next.
Serial number 21. Pradeep B.
Insurance company appeal challenging the liability.
R1, what happened to the notice?
Notice dispensed to R2. Non-taking of test steps.
Note, the step shall be taken in respect of R1 by 10th, same in all the cases, 10th of June.
Much.
Serial
Yes,
number
next.
22. Sanat Kumar KM,
Same, this also for steps, same date.
10/6. Serial number 23, BN Nagaraja,
This also same. Why they have posted these matters without the service of notice to the respondents? Ask the registered judicial to come. A waste of court's time.
yes. Serial number 24, BN Nag, 10/6. Serial number 25,
In all these cases, wherever notice is not there, time till that.
date distribute.
Yes.
11/6. 26, 11/6.
Dispensation noted to R1.
11/6, 26.
R1 dispensation. In 26 R1, no memo dispensed with. Then what is the insurance company? Tata AG General. Mr. Janardhan Reddy is directed to take notice. Yes.
Serial number
Next.
27. 27, that is the HR.
Steps is taken in respect to R4.
It is submitted that they've already taken steps. Post after service of notice 28.
Serial number 28, Manmohan PN.
We have paid the process fee, notice may be
It
reissued.
is submitted that the needful is done. List after service of notice. Yes, next.
Number 29, RB Deshpande. And the delay of 55 days.
Yes, Pradeep.
Please.
What about this?
Let,
Any scope for?
No, they have not served the appeal memo so far. It may be have it on Tuesday.
Number
my
1
time.
of 20 is filed to condone the delay of 55 days in filing. But same condone, admit post to file hearing.
Serial number 30,
Same IA 1 of 18 to condone the delay of 52 days. Condone, admit final hearing.
serial number 31,
This case I appeal for the respondent.
167 days.
167 days condone, final hearing, admit.
Serial number 32, KK Vasan.
For the delay of 978 days.
This is delay of 978 days.
IE copy is not been served.
I have given copies of the things.
On condition will,
Interest may be waived.
IA number 1 of 18. So condone the delay of 978 days on condition.
Connected matter.
Steps to
We'll take steps.
Connected matter is there.
Connected matter.
In the connected MFA 5177 of 2015, the respondent shall take steps by same date, give the June 10.
11.
Yes, next 33.
Serial number 33. Serial number 33, Kalpana PB.
Pradeep. Will condone the delay on condition.
Please.
IA 1 of 18, 1453 days on condition. Non-filing of acknowledgement for having deposited the amount before the tribunal. What is this?
We have to produce the acknowledgement having deposited the amount.
Kalpana is?
Kalpana, owner of the vehicle, she is.
Oh. Next 33.1.
33.1, steps to R2.
Next 34.
Serial number 34,
IA 1 of 18.
I am for appellant.
The delay of 71 days in filing. Condone, admit, final hearing. Next.
serial number 35, Shripad V Shastri.
76 days delay, my lord.
Yes, next.
Serial number 36, Harsha SP. 467 days delay.
Yes, 467
Allowed.
days on condition.
Yes.
Admit,
Serial number
final
30,
hearing.
37, Mohammed Sharif.
89 days condone.
Serial number 38.
Condone, admit, final hearing.
Yes.
Next
Number
is 702 days
38.
on condition, 38 condone, final hearing.
Serial number 39.
I am for recalling, my lord.
I appeal for R1, my lord.
And delay.
182 days on condition, condone.
And recalling the order dated, my lord.
What is the recalling?
DNP, my
Earlier
lord.
it was dismissed.
Dismissed for non-prosecution.
This 39 after vacation. Next 40.
Serial number 40, Shripad V Shastri.
My lord, I am for appellant.
5
5
days.
days.
Admit, final hearing.
Serial number 41.
206 days. IA number 1 of 18, condoned on condition, admit, final hearing.
Serial number 42, 42 to all admissions matters.
In these matters where both sides are ready,
42, 43.
42 to 47.
43, I am ready, my lord.
Who appears for 43?
Srimati
Radha.
Radha.
Where both sides are ready from 42 to 47.
I appeal for 40, or to in 45, my lord.
42 to 47, admit post for final hearing.
Serial number 48, 48 to 51. 48 to 51.
Admit.
Finally. Serial number 50, 52 to 57.
51.1. 51.1
Publishing of
for taking steps a week's time.
No, my
Not
lord, I
week's
will take
time,
a substitute
till-
service, my lord, for 51.
You already filed?
I need to file.
By June 10th, application for substitute service shall be filed, or else the plea shall stand dismissed. Next 52.
52.
From 52 to 57, in any case, both sides are ready.
Serial number 55, my lord. It may be posted for final hearing. my
No, it is going to, all are going to be posted for final hearing. Admit post for final hearing.
Serial number 58 to 63.
I'm for appeal for respondent. Judicial order already ಆಗಿದೆ ಸ್ವಾಮಿ. ರೆಗ್ಯುಲರ್ ಲಿಸ್ಟ್ ಅಲ್ಲಿ ಕೂಡ
Admit post for final hearing.
Serial number 64 to 68.
Same order.
Same order. Serial number 69 to 74.
Same order.
Serial number 75 to 79.
75 till 75 admit.
Admit to
71
all
and
others are
calculate.
final hearing.
71, I have calculated.
You have calculated.
71 and 70.
71 on 16th.
72, no sir.
76.
76, sir. That is also on 16th.
You are ready with 76?
Please.
What is the calculation?
But calculation, some enhancement is required. 76 ಅಲ್ಲಿ.
76 list is marked on 15th.
Both, no, 76 and
76 and 70? The other matter also will come
71
on
and
that.
76.
71
Yes.
and 76.
So in all these matters, who are ready? So the insurance company, the officers should have come. When the court have asked them to come.
We will intimate.
Some of the officers were present.
In the morning, that is over. Like it will continue in the afternoon also. They should have been there.
Now Sriram General Insurance Company officer is
Bajaj
present.
officers are-
We have settled, I have reported the settlement based on their approval.
Where is he?
She was standing here, now just now is here. She was
Like
present.
what would have happened if they are not interested for that? I would have posted the matters like how I am dealing with and I would have disposed of. It's waste of court's time.
We'll intimate.
This is not going to work out like this. Let the old matters be posted from Monday.
77, I appear for the respondent. 77, I appear for the respondent.
70?
7.
Who appears to the respondent?
I'm for the respondent, my lord. The case artist.
Mr. Dabali. All these matters.
103, my lord.
Don't give a date. Let's say after vacation.
Serial number 103, it is a case of death, my lord. I am ready. 103. 103. 103.
Who appears for the respondent? A.N. Krishnaswamy.
Krishnaswamy, death case, my lord. Can be disposed of.
16th we will take up.
90
Yes.
melon. Serial number 90 melon.
90.
Please. Ready melon. Ready.
Ready.
melon.
Who appears as the respondent? Rajashekar. 90 also on 16th.
97 also kindly be on 97, serial number 97.
97.
Yes.
When?
It is on quantum, my lord. 16th it can be.
97, 16th.
Please.
Any other matters on 15th or on 16th or 17th? All remaining matters after vacation. Don't give one date, just after vacation.
Serial number 45 also on 16th.
Whatever numbers they ask, post it on.
Serial number 45.
What is that? That also let it come on 16th. Ask research judicial to come.
Madam, 33. Nandu 50. 33 yes. Checks 50.
Admit. Admit post for hearing.
After vacation, Vidya, serial number 97. ನೀವೇ ಮಾಡ್ಕೊತೀರಲ್ವಾ 16-4
ಮೇಡಮ್ ಏನೋ ಬರ್ಬಿಟ್ಟಿದ್ದಾರೆ ಅದಕ್ಕೆ
ಆಫ್ಟರ್ ವೆಕೇಶನ್
ಮೇಡಮ್ ಎನ್ಸಿ ಹೇಳ್ಬೇಕಿತ್ತಾ ಜಾಯಿಂಟ್ ಮೆಮೊನ 15 ಹಾಕ್ತಿಲ್ಲ
ಅದು 6 ಜಾಯಿಂಟ್ ಮೆಮೊ ಅಂತ ಇರೋದೆಲ್ಲ ಪೋಸ್ಟ್ ಆಗ್ಬೇಕಂತ ಅದು ಲಿಸ್ಟ್ ಕೊಡಿಪ್ಪ ನನಗೆ
ಅಲ್ಲೂ ಕರೆದ್ರಾ
ಕರೆಕ್ಟ್ 16th ಹಾಕಿ ಅಂತ 23 ಹಾಕಿ 23 ಹಾಕಿ ಎಕ್ಸ್ಟೆಂಡ್ ಅವರಿಗೆ
17 ಕೇಳಬೇಕು
ಸರ್ ವೆನ್ಸ್ಡೇ ಅಂತ ಹೇಳಿದ್ರು ಸರ್ ಅಲ್ಲ ಕಾಲ್ ರಿಸೀವ್ ಮಾಡಲಿಲ್ಲ ಮೆಸೇಜ್ ನಾನು ಇಲ್ಲಿ ಸ್ಪೀಡ್ ಅನ್ನಿಸ್ತು ಅಷ್ಟೇ ಡೌಟ್ ಬಂತು ನಾನು
ಇಲ್ಲ ಇಲ್ಲೇನಿಲ್ಲ ಕರೆದಿಲ್ಲ ಹಂಗೆ ಅಸೈನ್ಮೆಂಟ್
ಇದೆಲ್ಲ 16-4ಕ್ಕೆ 16-4ಕ್ಕೆ ಡೇಟ್ ಇದು ಜಾಯಿಂಟ್ ಮೆಮೊ ಇರೋದು ಅದು
ಆಫ್ಟರ್ ವೆಕೇಶನ್ ಅಷ್ಟೇ
First for final hearing. Dismissal ಅವ್ರದ್ದೇ ಡೇಟ್ ಮೇಡಮ್ ಟೋಟಲ್ 25 ಕಾಲ್ ಮಾಡಕ್ಕೆ ಹೇಳ್ತೀರಾ ಇಲ್ಲ ಇದೆ ಅಂದ್ರೆ ಅವ್ರ ಇಲ್ಲ ಅಂದ್ರೆ ಇಲ್ಲಾಂದ್ರೆ ಲ್ಯಾಂಡ್ಲೈನ್ಗೆ ಮಾಡಕ್ಕಿಲ್ಲ ಅದೇ ಅವ್ರ ಅದು ಡೇಟ್ ಕೊಟ್ಟಿರಲಿಲ್ಲ ಅದು ಡೇಟ್ ಹಾಕ್ಬೇಕು ಅಂತ ಹೇಳ್ಬೇಕು ಅದಕ್ಕೆ ಅದನ್ನೇ ಕೊಟ್ಬಿಟ್ರಲ್ಲ ಅವರು ಅದಕ್ಕೆ ಅದು 15-4 ಜಾಯಿಂಟ್ ಮೆಮೊ ಅಂತ ಹಾಕಿದ್ದಾರೆ ಅದಕ್ಕೆ ಸೀರಿಯಲ್ ನಂಬರ್ 107 ಇಲ್ಲಾಂದ್ರೆ ನಾನು ಫೋನ್ ಮಾಡ್ತೀನಿ ಫ್ರೀ ಪಾಸ್ ಅವರಲ್ವಾ ಪಾಸ್ ಅವರ್ ಕೇಳಿದ್ರಲ್ಲ 15ಕ್ಕೂ 16ಕ್ಕೂ ಕೊಟ್ಟಿದ್ದಾರೆ ಇದು ರೆಗ್ಯುಲರ್ ಲಿಸ್ಟ್ ಅಲ್ಲಿ ಬಂದಿರೋಲ್ಲ ಇವಾಗ ಫೈನಲ್ ಬರ್ತಿದ್ದಾರೆ ರೆಗ್ಯುಲರ್ ಲಿಸ್ಟ್ ಅಂತಾನೆ ಇಲ್ಲ ಇವಾಗ ರೆಗ್ಯುಲರ್ ಲಿಸ್ಟ್ ಬಂದಿದೆ ಇವಾಗ ನಾವು ಬರೀ ಲಿಸ್ಟ್ ಇವಾಗ ಏನು ಹೇಳಿದ್ದಾರೆ ಅಷ್ಟೇ ನಾನು ಫಸ್ಟ್ ಲಿಸ್ಟ್
ಅಡ್ಮಿಟ್ ಇಲ್ಲಿ ನೋಡಿ ಟಿಸಿಆರ್ ಇಂದೆಲ್ಲ ಇದರಲ್ಲೆಲ್ಲ ಟಿಸಿಆರ್ ಕಾಲ್ ಮಾಡಿ ಫೈನಲ್ ಹಿಯರಿಂಗ್ ಮಾಡಬೇಕು 16ನೇ ತಾರೀಕು ಎಲ್ಲ ಜಾಯಿಂಟ್ ಮೆಮೊ ಇರೋದೆಲ್ಲ 16ನೇ ತಾರೀಕು ಅಂತ ಹೇಳೋರೆ ಈಗೊಂದು ಅಲ್ಲಲ್ಲ ಜಾಯಿಂಟ್ ಮೆಮೊ ಇರೋದು 16 ಬರೀ ಕ್ಯಾಲ್ಕುಲೇಷನ್ ಇರೋದು 15 ಇಲ್ಲಿ ನಾನು ಬರ್ಕೊಂಡಿದ್ದೀನಿ ಅಲ್ಲಪ್ಪ ಇಲ್ಲಿ ನಾನು ಬರ್ಕೊಂಡಿದ್ದೀನಿ ಜಾಯಿಂಟ್ ಮೆಮೊ ಅಂತ ಇರೋದು ಅದು 14ನೇ ತಾರೀಕು ಬರ್ಕೊಳ್ಳಿ ಬಿಂದ್ಯಾ ಲಿಸ್ಟ್ 2 ನಲ್ಲಿ ಸೀರಿಯಲ್ ನಂಬರ್ 3
15ನೇ ತಾರೀಕು ಕೊಡಿ ಮೇಡಮ್ ಬರ್ಕೊಟ್ಟಿದ್ದಾರೆ ಮೇಡಮ್
ಬಿಎಲ್ ಫೈಲ್ಸ್ ಎಲ್ಲ ಅಲ್ಲೆಲ್ಲ ಹೋಗಿದೆ ಎಲ್ಲ ಕಳ್ಸ್ಕೊಡಿ. ಹಾ ಎಲ್ಲ 15ನೇ ತಾರೀಕು ಇದೆ.
ಎಲ್ಲ ಗಾಡಿಗೆ ಹಾಕ್ಬಿಟ್ಟಿದ್ದೀನಿ ಅದೆಲ್ಲ ಮಿಕ್ಸ್ ಆಗಿ ಏನು ಅಲ್ಲೇ ಬರ್ಕೊಡೋದು ಅಲ್ಲೇ ಸೈನ್ ಮಾಡ್ಬೋದಲ್ಲ
ಸೈನ್ ಮಾಡ್ಕೊಂಡ್ರೆ ನಾವು ಪಟ ಪಟ ಕಳಿಸ್ತೀವಿ ಎಲ್ಲ ಇಲ್ಲೊಂದು ಫೈಲ್ ಇಟ್ಟಿದ್ದೇನೆ ಏನು ಮಾಡಿದೆ ಅದೇ
serial number 3 list 14 ಫೈಲ್ ಅದು both the learned council agreed for amount ಅದು ಇಲ್ಲ ಅದೇನು agreed for amount joint memo file ಮಾಡಿದ್ರು joint memo file ಮಾಡಿರೋದು ಮಾಡಬೇಕಾಗಿರೋದು and they have to file the joint memo in that regard ಬರಿಬೇಕು cost ಎಷ್ಟು ಮಾಡ್ತಾರೆ 6% interest ಅಂತ ಹೇಳಿದಾರಲ್ಲ ಅದು joint memo amount ಬೇಕು 6% interest amount ಬೇಕು the council agreed that the insurance company has agreed to pay compensation of an amount of rupees so and they will be filing the joint memo before the local audit ಹೇಳಿದ್ರೆ joint memo ಅಂತ ಹೇಳಿದ್ರೆ they will be filing the joint memo in that regard the enhanced amount shall carry interest 6% ಅಷ್ಟೇ list is matter and so ಅಷ್ಟೇ
ಇದೊಳಗಡೆ ಜಾಯಿಂಟ್ ಮೆಮೊ ನಿಮಗೆ
ಫಸ್ಟ್ ಲಿಸ್ಟ್ ಎಲ್ಲ
ಅಲ್ಲ ನಿಮ್ ಜಾಯಿಂಟ್ ಮೆಮೊ ಫೈಲ್ಸ್ ತಗೊಂಡಿದ್ದೀರಾ ನಿಮ್ದು ಏನು ಆಗ್ಲಿಲ್ಲ ಅಲ್ಲ
ಫಸ್ಟ್ ಲಿಸ್ಟ್ ಬೇಡ ಅವ್ರಿಗೆ ಹೇಳ್ತಾರೆ ಡೈರೆಕ್ಟ್ ಇವರು ಅವ್ರಿಗೆ ಹೇಳ್ತಾರೆ ಅಷ್ಟೇ ಹಾಕೋದು ಡೇಟ್ ಇರೋ ಫಸ್ಟ್ ಡೇಟ್ ಇರೋ ಅದು ಬೇಕಂದ್ರೆ ಬರ್ಕೊಬಿಡಿ ನೀಟಾಗಿ ಹೇಳ್ದೆ ಅಲ್ವಾ ಬಿಂದ್ಯಾ ಹಂಗೆ ಬರ್ಕೊಂಡು
ನಿಮ್ದು ಜಾಯಿಂಟ್ ಮೆಮೊದೆಲ್ಲ ಫೈಲ್ಸ್ ಕೊಟ್ಬಿಟ್ರಾ
ಒಂದು ಡ್ರಾಫ್ಟ್ ಕೊಟ್ಟಿದೀವಿ ಇನ್ನೂ ಬರ್ಲಿಲ್ಲ ಸೇಮ್ ಅದೇ ತರ
ಅದೇನೇ ಆ ಜಾಯಿಂಟ್ ಮೆಮೊದೆಲ್ಲ 16/4
ಎಲ್ಸಿ ಫೋನ್ ಮಾಡಿದ್ರಾ
ಆಗತ್ತಿಲ್ಲ
ಅಲ್ವಾ
ಹಾ 16/4 ಕೋರ್ಟ್ ಮುಂದೆ
ನೆನ್ನೆ ಹೇಳಿದ್ದು ರೆಫರ್ಡ್ ಬ್ಯಾಕ್ ಟು ಲೋಕ್ ಅದಾಲತ್ ಫಾರ್ ಫೈಲಿಂಗ್ ಮೆಮೊ ಅಂತ ಹೇಳಿದ್ರು
ಯಾರು
ಮೇಡಮ್
ಅದಾಲತ್ ಅಂತ ಹೇಳಿದ್ರಾರ ಫಾರ್ ಜಾಯಿಂಟ್
ಫೈಲಿಂಗ್ ತಗೊಳ್ಳಿ The matter is referred back to the Lok Adalat for filing a joint memo ಅಂತ ಹೇಳಿದ್ದಾರೆ before the Lok Adalat. Lok Adalat matters ನಿಮಗೆ ಹೇಳಿದ್ರು
ಅಲ್ಲ ಇವಾಗ ಅದೆಲ್ಲ 15ನೇ ತಾರೀಕು ಇದ್ರಲ್ಲಿ ಅಂದ್ರೆ ಅವರು ಹಾಕಲ್ಲ
ಮತ್ತೆ ನಾನು ಮಾಡಿಲ್ಲ ಒಂದು ಡ್ರಾಫ್ಟ್ ಕಳಿಸಿದ್ರು
ಅದ್ರಲ್ಲಿ ಮೇಡಮ್ದು ಕ್ಯಾಲ್ಕುಲೇಷನ್ ಇದೆ ತಾನೆ
ಕಳಿಸ್ತೀವಿ
ಅದು 15ನೇ ತಾರೀಕು ಹಾ ಆ ತರದೆಲ್ಲ ಇರೋದೆಲ್ಲ ಜಾಯಿಂಟ್ ಮೆಮೊ ಇರೋದೆಲ್ಲ 16ಕ್ಕೆ ಯಾರ್ಯಾರಿಗಾಗಿದೆ ಅವ್ರಿಗೆ ಗೊತ್ತಿಲ್ಲ